Hello, good morning everyone, and welcome to this new event of the European Centre of Excellence on the Regulation of Robotics and Artificial Intelligence. Today we're here to discuss the recent proposal by the European Commission to regulate artificial intelligence. And I'm very excited to have all of you here and to welcome you even virtually in Pisa. For those of you that do not know it, EURA is the Jean Monnet Center of Excellence funded by the European Commission through the Jean Monnet Action. And EURA is instituted inside the DIRPOLIS department, that is the Department for Law and Political Science here at the Scuola Superiore Sant'Anna. And I will leave the floor to Professor Gaetana Morgante, our director, to give a welcome remark.
Indeed, Andrea, and welcome to the Scuola Superiore Sant'Anna and the DIRPOLIS Institute. It's a special pleasure for me and the Scuola to host these important events on the European proposal for an AI regulation. Technology regulation and technology application in the most different fields, even those of our everyday life, is a strategic research line for the DIRPOLIS Institute itself and the Scuola more in general. The activities of the EURA Center of Excellence and of the colleague, Professor Andrea Bertolini, have been more and more developed over the years, being, let me say, pioneering at the Scuola since the very beginning of the famous project RoboLaw, co-coordinated by Andrea with the colleague Erika Palmerini. The regulation of technology is also a very important pillar of our strategic project, or the DIRPOLIS strategic project on governance for inclusive society. And it's very important for me to underline how regulation of technology is essential, especially in these very difficult moments we are experiencing now, to make it possible to benefit of technology in compliance with fundamental rights, fundamental principles, and guarantees. In a broader perspective, this balance is a challenge even for democracy. And universities, public and private institutions can take part in this very important process. I'm really confident that the discussion of today will be a significant part of this process. And so have a very good discussion. Thanks indeed to all of you for being here and contribute to this important discussion. And let me leave the floor to the colleague Andrea Bertolini.
Gaetana, for these very kind words and very important remarks. As you saw, today's title for the panel is Europe Rules AI. It's not a typo in the title, it's a voluntary kind of spelling to use a slang that is basically underlying the attempt that the European Union is making not only to rule, so provide regulation to artificial intelligence, but also to kind of take the lead internationally in regulating advanced technologies. So I like to say, after so much talking about ethics and ethical implication, now Europe made a move to finally talk about the law of artificial intelligence. Now, when I speak to engineering students primarily, but also lawyers, I like to make this example. If some engineer overnight invented a time machine, and that time machine was used the next day, absent any specific regulation of time travel, and somebody yet got injured using the time machine, that person could sue the creator of the time machine before a judge. And the judge would not be able to say, well, we do not have a specific regulation of time travel, so will not solve the case. He would have to resort to existing laws and use analogy to find a solution to the specific case. So this is to say that everything is regulated the moment it exists. There is no real legal gap. The fundamental question is always whether that is the best, the ideal regulation that we would want to have in that specific case. And I believe that the European Union tried and made the effort to come up with good regulation, and we'll have the entire morning to debate whether actually they achieved that intended result, or whether there are some criticalities and some observations to be made. So within this framework, I don't want to take any more of our time, just to say that to some extent we managed to invent time travel. It is a pity that you cannot be here joining us in person in a beautiful sunny day, early summer sunny day in Pisa. But the good part of it is that we managed to connect people literally from all over the world. And to some extent, this very event is a bit of time travel, because we have Lydia Bennett-Moses connected with us from Australia, for whom it's still Monday evening. And while for the rest of us in Europe, it's already a Tuesday morning. So before leaving the word to our today's chair, Thomas Streinz, I'll leave the floor to Francesca, that will explain to us briefly how we're going to handle the debate, because this is intended to be an event with short presentation, but a lot of interaction also from the audience, and Francesca will just explain to us how this is going to happen. So I'll leave her the floor for a moment.
Thank you very much, Andrea. And of course, I'm very happy to echo what Andrea just said and welcome you all to this event. Very briefly, I want to tell the audience how this event is structured. So actually how the interaction is structured, because how the event in itself will develop will be better explained by our chair, whom I will introduce in a second. But again, as Andrea was saying, we will have a first part of kind of very short presentation on the proposed regulation, and then a longer debate among the speakers and between the speakers and the audience. So everyone who's connected is very much welcome to interact as much as possible. You do have a chat in which you can write and interact if you want, but if you want us to kind of address a question specifically, please use the Q&A function. And in this way, your question will be included in the topics to address during the discussion. That being said, I also have the pleasure to introduce our chair. He himself will introduce the other speakers, so I will not take too much of his time for that. And today's panel, as I was saying, will be chaired by Thomas Streinz, who is the Executive Director of Guarini Global Law and Tech and Adjunct Professor of Law at NYU Law. He's also the convener of the Guarini Colloquium Regulating Global Digital Corporations, together with Benedict Kingsbury and Joseph Weiler, and he taught courses on global tech law and global data law at NYU. His research covers digital governance, the regulation of global data economy, and global law and technology. And with no further ado, I'm very happy to leave the floor to our chair, Thomas Streinz, and to our invited speakers. Thank you very much.
Thanks a lot, Francesca and Andrea, for inviting me to this amazing panel, which will give us plenty of time to discuss this important proposal by the European Commission on a future Artificial Intelligence Act. So thanks a lot for making this possible and for inviting me to chair a panel with really esteemed colleagues who will shed light on this proposal from different perspectives. And the way we will conduct the conversation will be the following. We will start with a presentation by Tatjana Evas from the European Commission, who will introduce the proposal to us. And then we'll have a seed round during which quick fire hot takes by our panelists will be offered for 5 minutes each. And on that basis, we will transition into a conversation among the panelists that I will try to moderate before opening it up to a broader conversation with all of you who are watching around the world. So without further ado, I think I would like to turn it over to Tatjana Evas, who is a legal and policy officer at the European Commission's Director General for Communications, Networks, Content and Technology, or better known as DG Connect, who will tell us about this proposal and the rationales and the kind of thinking that went into it from the from the perspective of the European Commission. Tatjana, the floor is yours.
Good morning. Just give me a second to share my screen. So good morning, everyone, and thank you for this nice introduction. Thank you, Andrea and Francesca, for organizing, and all the team for organizing. It's nice to be in Pisa, even if it's virtual. And also thank you for already pre-conference discussions, which were in questions. So I will present proposal on behalf of European Commission, but I just want to make a little footnote that in the debate, I will participate as an academic, and so don't consider me as a kind of at the exam question, Commission versus everyone. So I hope that this debate will be structured more as an interaction, and I will express my personal opinion as an academic rather than commission representative. But still with this, yeah, I'm very open and will be happy to answer all the questions. And with this, just to give a bit of background, what I was thinking would be the best for presentation today, I will not go article by article of 80 pages proposal, but rather to try to give you a bit of our context thinking, what went into this proposal while we were drafting it. So to give you a bit of more context, how to understand the overall structure. And I hope this would facilitate and partly maybe provide already answers to some questions which you had in mind. And with this, I also just wanted to say, we had an event also organized by Pisa Sant'Anna a few weeks before the adoption of the regulation, and it was very interesting because there were different expectations, and some of the scholars have voiced their opinion that, oh, probably it will be another procedural nonsense which will not help much. So I'm afraid I will disappoint those who had expected that or thought that it will be not more than that. So, and I hope with next 15-20 minutes, I will be able to convince you and explain more of the rationale which went behind. So basically, I want to take this presentation in 3 steps. So my major emphasis, of course, will be on the proposal, but I just want to highlight as a first step a bit of the context where this proposal comes from. So just really very quick background. Then I also want to emphasize what Commission has proposed in April 2021 is not just proposal for Artificial Intelligence Act, but actually a package of measures, which is also very important in the discussion, that it's a two, if you want to say, 2 legs, of the proposal, and both of them are actually quite important, and one explains another, and one other one helps to also explain another one. So it's basically to run quick in AI, Commission thinks that these 2 elements are very much very important. And then by way of conclusion, I just highlight what are the next steps in our radar. So in terms of milestone, what I want to highlight, I will not discuss. I think many people, especially on this panel, know very well. But just to highlight to those maybe who are more new to the debate, that actually this regulation on AI does not come out of blue. It's actually a result of 6 years of intensive work at the EU level, first started by European Parliament, 2017 resolution on robotics and artificial intelligence, and of course the white paper on AI and communication on AI, high-level expert groups. So it's not only one expert group, but two groups have been functioning. And then, of course, also in 2020 proposals, legislative own initiative reports by European Parliament on ethics and liability. So, and we had also public consultation and a lot of stakeholders consultations within the framework of white paper, but also larger. So this is partly also replies to the question why horizontal framework and aren't we rushing too much? I think my personal opinion again here that we have put 6 years of actually quite a lot of debates on different levels, which fit into this proposal. So I would not call it rushing into something which is based on 6 years of research and a lot of intensive consultation. Now, if we look specifically at the now Commission package, of 2021, so basically the overall aim is to, of course, contribute to enabling of EU to become world-class AI hub, but by also ensuring a trustworthy AI, and trustworthy is really a key, because in 2020, just to recall, in 2020 white paper on artificial intelligence, Commission said that we have a two-pronged approach to regulation or vision to artificial intelligence. We want to build ecosystem of excellence, but also ecosystem of trust. And they are forming like one holistic ecosystem which relates to artificial intelligence. And this trust is really key in this kind of vision. Also, before we go into specific regulation in artificial intelligence, the overall approach of European Commission, which has been decided consciously, is to regulate artificial intelligence in stages. So it's not, it's a horizontal proposal, what we will discuss today, but it's not a comprehensive proposal which covers all possible topics related to artificial intelligence. And just specifically what is mentioned in the white paper of 2020, but also in the Commission working program. So first we come up, the Commission comes with Artificial Intelligence Act. In parallel, now there is a lot of preparatory work for revision of liability rules, as well as revision of safety legislation. So these measures will come at the end of this year, beginning of the next year. So again, the questions related to damages, questions related to overall safety of the product, they are now in pipeline. So the revision to general safety legislation will come shortly, and of course we had also proposal for machinery directive. So I think this is also very important to keep it in mind, because it's one element in the network of instruments which relate to regulation of artificial intelligence. Now, if I specifically turn to the package, as I briefly mentioned, includes 3 documents. So first, communication. Communication outlines the key political messages or visions of the Commission. And then we have 2 kind of more substantive documents. So one is called Coordinated Plan on Artificial Intelligence, 2021 review. Its reviews already coordinated plan adopted in 2018. And then Proposal for Artificial Intelligence Act. So first, I will discuss the Proposal for Artificial Intelligence Act, and briefly at the end of my presentation also mention why this coordinated plan on AI really plays an important role in overall debate. Now, if we look at the main reasons for the regulation, so a proposal for main reasons for Artificial Intelligence Act. So our starting point when we started to think about impact assessment was, yes, it's true that European Union has a solid framework of already existing legislation. We have GDPR, we have fundamental rights, other fundamental rights legislation, we have product safety legislation, we have like many different pieces of legislation, and some argue that actually might be sufficient because, yeah, I mean, for not every new technology we would introduce or completely rehaul our legislative framework. This was our starting point. Yes, we have already quite solid framework. However, trying to understand more the essence of artificial intelligence technologies per se, or why this type of technologies or set of technologies is different from any other technologies, we kind of distilled 5 main characteristics or features of artificial intelligence systems or technologies, which in our opinion create additional risks or safety to additional risks to safety and fundamental rights. And these 5 characteristics, which are discussed in detail again in impact assessment, are complexity, opacity, unpredictability, autonomy, and data-drivenness. So basically, if to put it in very simple way, what we want to address by this Artificial Intelligence Act, this specific features of artificial intelligence. So what we want to target is these risks which are generated by artificial intelligence systems, which are not, in our opinion, fully captured by the existing framework. So it is in addition to what we already have, and with specific emphasis on these 5 specific characteristics. Because what we kind of, based on our analysis, established that these characteristics, and they may not necessarily be present in all AI systems, so that could be a combination of different systems, but they make application and enforcement of the existing rules more challenging, or create a lot of gray areas which are not currently regulated. So it leads to uncertainty and possible fragmentation, because different legal systems then try to address these issues in a different way. And for example, regulation of drones, or now upcoming regulation possible of autonomous vehicles is some of the examples where member states try to take actions, and they may interpret this technologies as systems in a different way. So based on this context, we decided that the best way to go forward is to draft a tailored regulatory response exactly to address the specific features, and with 2 important risks which we want to address. We wanted to address, and this impact is related to safety, but also risks related to fundamental rights and values. So, and this is the result of the Commission's proposal for regulatory framework. So, I mean, of course, Artificial Intelligence Act is a complex document, but if I had to give 3 main elements of the proposal, then I would say that 3 main contributions to the current key and the debate are 3 features. First is this proposal for the first time defines in legal terms what AI system is. And of course, it's not an easy task. And I come back later in my presentation why we decided to go for approach as we propose. But this is essential because it's for the first time the EU context provides a definition of AI system. And secondly, I think it very importantly, which is both important for businesses and also for people in the European Union, it defines what AI use cases and under what conditions can be put on the market or used in the European Union, or which systems are banned. So it helps to define the boundaries of what, from European Union perspectives, are permissible uses under which conditions, and which use cases of AI systems should be banned from European Union. And then, of course, the bulk of the regulation is about high-risk AI systems. So this is the main focus. And for high-risk AI systems, we set the requirements, we spell out obligations for providers and users, defined relevant bodies and applicable procedures before the system put on the market, but also after the system is put on the market, plus we set the governance mechanism. So this is the key. It's not the exhaustive list, what is covered in the proposal, but this is the key elements which add the new features which are completely not yet covered with the existing legislation. Now, I will take you through quickly the 6 key principles or concepts from which my point of view are really central to this regulation. So first, what we have heard for last 5 years, please note, no hope regulation, don't kill innovation, try to set up a system which would make EU competitive in a global context. To reply to this claim and aim to not to over-regulate and support innovation, we try to build as much as possible on the existing legislation, procedures, and governance. So we tried not to duplicate what is already exists. So for example, if under sectoral legislation, already well-established type approval legislation, for example, for cars, we try to integrate it. This is also partly explains why, from a legal normative perspective, some find the overall build-up of the system a bit complex, but this is due to the nature of different legal acts within the European Union context, and I also briefly come back to that later. Another thing, what was really essential to us is to build a system which will be future-proof, which is a major challenge for the technologies, the emerging technologies, which are yet in development as artificial intelligence technologies. And in order to meet this future-proof challenge, let's say, we tried to propose two sets of innovations. And I really personally think that what we propose in terms of how to approach this regulation is really innovative in the context of European Union law. First of all, what is future-proof is really the definition, and this two-step classification of the high-risk use cases. Again, that's one of my next slides in more details. But here, just to say that we tried to make this definition constructed in a way that it would be that we would be able to amend this as the technology develops and as necessary to make it more fit for the purpose. In terms of regulatory approach, we followed the new legislative framework logic. So this builds on the product legislation, which basically the underlying logic of this new legislative approach builds on the following intervention logic. So at the legislation level, you set up high-level requirements, but the let's say, operational implementation of requirements is done through harmonization and standardization procedures. So basically, the legislator sets the aim, but legislator with private parties, for example, working through standardization agencies, try to operationalize how to make, for example, the requirement on data operational. This also helps to be more in touch with the different stakeholders and also be more dynamic in terms of the needs, operational needs both of regulator and the industry and the people. So this is more iterative approach, which involves more stakeholders rather than trying to set up very technical legislation already in the legislation. Then what is the favorite topic of many people, risk-based. What actually risk-based approach for us means, first of all, we don't regulate technology. As you see in the text, we don't speak about AI, that we regulate AI technologies. What we regulate are concrete use cases or concrete applications of certain AI technologies. And what we cover is risk to safety and fundamental rights, so health, safety, and fundamental rights. And what actually, in very simple words, risk-based approach means that the higher the risk, the stricter the requirements for this specific use cases of this technology. So here, the risk-based means actually regulation proportional to the risk that these certain use cases may trigger. Then the fourth, I guess, key principle is that we wanted to create a level playing field for EU and non-EU players. For us, the origin of a producer or user is irrelevant. So what is important, if the product is used or in the European Union or put in market in the European Union, then the same rules apply for the company which is EU, like origin EU or non-EU origin. So here we don't differentiate. Then what is usually also misunderstood, or how to say, the logic of the text, it's very interesting because when you discuss this piece of legislation with people who come, for example, from GDPR background or from services, they don't really can easily relate to this piece of legislation, and it's very clear why, because in the European Union we had for very long a very strong dichotomy between product legislation and services legislation. Yeah. So, and what we follow is really product safety legislation logic and not services logic. So basically here the emphasis on making classical internal market rules for placing on the market and putting into service of the product. And of course here you could say, and that's correct, that AI is not classical product in classical sense. And that's what also where our innovation kind of comes from, because we treat AI system as a product of human action. Yeah, so this is still for us a product. Yeah, so, and this is the intervention logic, and the logic of the build up of a system comes from. So, and the sixth element is complementarity. I cannot underline it enough, because basically we apply a systemic approach to regulation, and we try to really build complementarity with existing pieces of legislation. So famous, of course, GDPR. Some say, yeah, that what does this? What is the interaction between Artificial Intelligence Act and GDPR provisions? This, I mean, in very simple terms, they complement each other. Yeah, so we don't replace GDPR, we don't undermine GDPR, we work together. So while analyzing this piece of legislation, you basically should think in a systemic approach. So now if I move to one of the most heated discussed topic of definition of artificial intelligence, how do we define artificial intelligence? We define it basically in 2 steps approach. So as you see in Article 2, you will have a definition, which is very broad. This definition is based or inspired by OECD definition. We have looked quite intensively what is the best way to go, and we decided or opted out for definition provided by OECD for a number of reasons. We think it's quite broad, flexible, but it also represents a certain degree of the if not consensus, but at least the opinion of, let's say, of the majority in the current debates, which both tries to be technologically nuanced, but also to provide a broader picture. But for us, it was not enough. I mean, we still wanted to have an operational definition or functional definition. So this for us was the first step. That's why we added this. In addition to this, we wanted to list in Annex 1 techniques or approaches to artificial intelligence. Why annex? And why, some people ask, why so many annexes? It's again purely technical solution to give more flexibility to this instrument, because to amend annex is much easier than to amend the treaty regulation provisions. So for us, it was important that this first element stays stable, but the elements or techniques which are put in annex are quite flexible. So if necessary, then this annex can be amended through delegated acts to include, for example, new techniques or new approaches, or some approaches could be more explained, etc. So in order to give this flexibility and not to take 2, 3, or 4 years, how it may take in the legislative process, we thought that we keep one element stable, so this definition, which is in Article 2, while what is in annex, when it's a more flexible element in order to fine-tune and define the main definition. So this is to ensure legal clarity, but also to provide for flexibility. Maybe just to jump a bit more in another criticism, which is usually voiced, is that when this definition of artificial intelligence is too broad, this is not fully correct, because again, if you read it together, so you have to look at the definition of artificial intelligence in Article 2, when you look at the techniques in Annex 1, but then actually what requirements apply, what requirements we set is only requirements set for high-risk AI systems. So basically the scope is then further reduced, and the requirements which we propose only apply, or primarily, not only, but primarily apply to high-risk AI systems, then further defined in Annex 2 and 3. So the scope is then defined even further. Now, in terms of scope, basically regulation is applicable to both private and public providers who place on the market or put into service AI systems in European Union. So we don't exclude public or private. So for us, everything is covered, both in terms of providers and users. Even if a provider is user or located in a third country, but the output is used in the Union. The only things which are excluded, and this comes from the international obligations which European Union has taken. So this, the only who is excluded are public authorities in third countries or international organizations who use AI systems in the framework of international agreements. And to put it in simple terms, for example, we cannot impose on Interpol, certification requirements. So another thing, what is excluded is the AI applications developed or used exclusively for military purpose. And here the emphasis is on exclusively. So dual use, for example, AI systems are covered, but exclusive for military purpose is not. This is also in big part relates to the legal basis on which this proposal is adopted. It's Article 114, internal market. But this is basically only 2 exclusions which apply to the scope of the regulation. Here I have a slide on provider, and next slide is about the user. So basically, provider is a person, again, public or private authority, which developed the system or places the AI system on the market. under its own name or trademark. So this is basically kind of similar to the concept of manufacturer in the EU product legislation. And this is the main actor who is responsible for ensuring compliance of AI systems and conformity assessment. The concept of user is a bit sometimes also confused because in our text of legislation, user relates to the natural and legal person who actually under whose authority the system is used. So it's not an end user who kind of the beneficiary, yeah, or subject to AI system, but actually that's the person who operates. And sometimes it means that user and producer, they can coincide, but sometimes it could be two different entities. So in some parts of the text, we indeed refer to end users, but through the text, but on only few places here, basically user should be understood as the person under whose authority the system is used. Now, if I move to risk-based approach, and I try to be short, I don't see the clock, but I think I should wind up quickly, and this we could bring in discussion. So basically, what we believe is that most AI systems will be minimal or no risk in terms of safety and fundamental rights. And here I want to underline that we just assess these two types of risks. Then we have the next layer, which is systems which we believe can have a transparency risks. So for example, bots. So here, and we have three specific categories which fall under transparency risks. So there, the main obligation is basically to make it clear to a human interlocutor that the human interacts with AI system. So this is the obligation. Then the bulk of the, like I said already, the requirements which we put are for high risk. And the next slide, I briefly explain how we define high risk. And then we have another red top, it's about unacceptable risk. Also, in terms of transparency and high risk, we are not mutually exclusive. So it's not either transparency or high risk. It could be subject to transparency obligations and high risk conformity assessment obligations. So they are complementary. So here, I think that's the bulk, and I try to explain why we have these two categories of the definition of high-risk AI systems. So why do we have Annex 2, and in Annex 2 we have A, B, and then we have Annex 3. Again, this comes from legal technicalities of the construction of EU law. So basically, in order to be complementary and systemic in approaching this existing legislation, under existing EU legislation, we have already quite a lot legislation which relates to safety of the product. So for example, medical devices, machinery. And within this safety product legislation, we have two categories of legislation. One is so-called new legislative approach legislation, and another is old approach. And in very simple terms, the new legislative framework follows what I have explained in the beginning. It allows for automatic complementarity. So for example, to a given product, it could be subject to machinery directive and subject to radio equipment directive. And then this would be complementing each other. So you don't need additional implementing stage in order for the additional requirements to be added. So from our purpose for this new legislative framework, which is listed in Annex 2, then when our legislative proposal becomes a law and enters into force, it will be automatically added to the catalog of already existing obligations related to that specific product. But we have another set of legislation, especially in the mobility sector. So for example, cars, planes, marine equipment, railways. It's so-called old approach legislation. This legislation is very technical, and usually already technical specifications related to safety are spelled out in these pieces of legislation. This type of legislation does not allow for automatic complementarity. Therefore, this legislation needs first to be amended in order for the requirements of this legislative proposal to be taken on board. So this is not comes from us, so to say, from the drafters of Artificial Intelligence Act, but from the structure of EU law, where we have to distinguish this logic of legislative intervention. But the aim is the same. So if the product is safety component of already regulated product under EU safety legislation, this is high risk. So basically, the first big category of high risk are all products which are currently regulated under the EU, which already defined as risky products for one or another reason. But within this safety components regulated products, we have two lines of legislation. Another very interesting and I think innovative addition is then, of course, AI systems, which are currently not necessarily regulated as under product legislation. And here you have 8 broad categories or areas. And you see they're quite broad, and they're further operationalized in Annex 3. Here I want to highlight that if this issue or AI system falls, for example, under the category of law enforcement, it's not automatically that all law enforcement or educational and vocational training systems are high risk. In order for them to be high risk, they must be listed specifically in Annex 3. And here again comes another misunderstanding, which sometimes comes in the discussions, but Annex 3, it's not case of examples. It's actually Annex 3, it's exhaustive list of what we consider at this moment contribute as a high risk use case. So here you will see the areas, yeah, but then in Annex 3 you have broad categories with specific use cases which we consider at the moment as a high risk areas or use cases. So if the product falls under this high risk AI system as defined by the proposed legislation, then 5 set of requirements will be applicable. And as you see here, it relates to data, documentation, transparency, human oversight, robustness, accuracy, and cybersecurity. You probably have looked at this in detail. Here, the key concepts are risk management process and intended purpose. We don't evaluate these requirements, or we don't set these requirements for high risk system in abstractum, but actually in the context and the light of intended purpose of AI system. Here, there's a summary of the main obligations set for providers and users. I will not go into detail into that at the moment, but they are in line with the, of course, the requirements. So the provider should ensure the quality management system and undergo conformity assessment. Then for certain AI systems, they should be registered in the EU database. Then a CE marking should be affixed, but also post-market monitoring is very important part, and the collaboration with the market surveillance authorities. For the user, the human oversight obligation is very important, as well as the obligation to use AI system in accordance with instructions of use, monitor and report serious incidents, and yeah, some of the so on. So for CE marking plays a really important role for high-risk AI systems. This is very classical scheme for existing product legislation. So first you determine whether product is a high risk, then you ensure that design and development, so not only the end process, but the whole already in design and development of the product is in compliance with AI regulation. Then you go for conformity assessment, then you receive CE marking, and then only after this you can place the system on the market to put it into service. Here again, to highlight what we try to do is the life cycle approach to seeing the artificial intelligence use system. So it's not only pre-market conformity assessment, but it's also post-market surveillance. And especially for the high-risk systems, which are not safety components of a product, we also envisage a database where the systems will be registered. So this is very important that we see it as complementary, both ex ante and ex post assessment of the systems. Sorry. So this is the list, and I know that we will come back to this in discussion about the prohibited practices. So here we have 4 big categories, and I'll for now park it for the consistency of time. So here, of course, the big question is always biometric identification and the difference between, because biometric identification sometimes under the proposed rules fall under high risk and sometimes under the unacceptable risk. And there are certain reasons why this distinction is made. Finally, also, we tried to implement measures related to innovation, specifically important here regulatory sandboxes and support for SMEs. And again, this is a question that we could happily discuss at a later point. Basically here was to elevate, especially for small and medium enterprises, the regulatory kind of burden, or provide the testing experimentation facility where under the structured environment where it could be guided through national authorities how to apply the existing requirements and make sure that we don't contravene or contradict the existing rules. And just by way of conclusion, a few slides on a coordinated plan on AI. This is another very unusual document for European Union. It's called Coordinated Plan on Artificial Intelligence because it's actually a commitment between European Commission and all 27 EU member states. So this is an interesting document for that matter because it is a common commitment where 27 EU member states together with Commission want to move on and what is the holistic vision in terms of where we want to develop. And this is designed as an operational action plan. What we want to do. And just as a funny, I guess, footnote, in the EU system, there is no specific type of document which this document could be classified because it's neither a document of member states nor a document of European Commission. Therefore, it had to be adopted as an annex to Commission communication because there is no special kind of designation to this document. And that's it makes it very special because it's one of this kind. But especially in the area of artificial intelligence, our feeling was that we really need to coordinate our action. And this is the synoptic overview of what is covered by this coordinated plan. And I think for research purposes, it's a very interesting document to look at because I know that the full attention of legal scholars on the regulatory proposal, but I think this is not less interesting because it provides an overview of, on one hand, what EU has or European Commission has taken in the last 3 years in the area of artificial intelligence across different areas, and also what Commission plans for next 5 years. So, for example, intellectual property rights are not really discussed in detail in regulatory proposal, but you will find something about this in this coordinated plan as a forthcoming action. Same relates to, for example, use of AI technologies in public sector or in mobility or agriculture. This provides a holistic approach with 4 key objectives. And of course, policy framework to ensure trust, as you see, is only one element. So in the third column, in the point 2 above, policy framework to ensure trust. It's again to bring us back to my opening. Let's say that this is only one element of the system, and therefore we should see and discuss it in this context. So this is in terms of the funding plan for artificial intelligence Europe. So this is also a game changer from compared to what we had before with the Digital Europe program and Horizon Europe program, as well as Recovery and Resilience Facility. We will have much more funding than before invested through European Union, and hopefully it will facilitate also private sector. And my very last slide about next steps as promised. So now the proposal is with co-legislators, with European Parliament and Council. Negotiations will start shortly. Then once adopted, there will be 2 years transitional period before the regulation becomes directly applicable. Since, as I mentioned, this piece of legislation very much relies on this new legislative framework. Already before the adoption, the formal adoption, the process related to development of standards with European standardization bodies and international standardization bodies will be starting shortly. We already hold preparatory talks. So I think next frontier for research will be really how to make now these requirements which are put in the legislation into operational standards which could be applied by the industry. So, and with this, I thank you for your attention, and I hope I was not too long. Thank you.
Thanks a lot, Tatjana. This was an incredible tour de force through very complex legislation, and also drawing attention to the policy framework and additional information that needs to inform the legal analysis that lawyers tend to focus on. I'm very glad that we are not only having lawyers on this panel so that we can engage in the kind of interdisciplinary conversation that is necessary to assess the role of legal regulation in comparison to other ways of influencing how these technologies affect our lives and how they govern. So with that, I want to turn it over to our other panelists who will have a chance to give their 5-minute remarks. And we will start with Lyria Bennett-Moses, who is the director of the Allens Hub for Technology, Law and Innovation, and also a professor in the Faculty of Law and Justice at UNSW in Sydney, Australia. I'm a huge fan of her scholarship, which is very broadly on law and technology, always theoretically informed and practically relevant. She's also written a book on artificial intelligence, robots, and the law, and also contributes to the conversations in standard setting bodies like the IEEE. So I'll turn it over to Lyria. The floor is yours.
Thank you. So greetings from the future, where I come to you from Tuesday evening on unceded Gadigal land in Sydney, Australia. So I'm conscious that I'm coming into this conversation from a very different place and a place that often has very different ideas about regulation. So you can take everything I say with that particular grain of salt. But what I wanted to talk about is one point that Tatjana made in her presentation, which is the fact that this is framed as rules for artificial intelligence. So I want everyone to sort of step back for a second and just ask, what kinds of technology make for good regulatory objects? And by that, I mean regulation that targets a particular technology rather than regulation that merely could be applied to a particular technology. So the GDPR data protection rules apply to AI, which is a point that Tatjana made, but they're not limited to AI. So if I collect data and use ordinary statistics rather than AI or keep my records on paper, I still fall within the regulation. So if we think about what kinds of technology make good regulatory objects, a good example of one that does is the ban on human reproductive cloning. It's not the end state that's prohibited. We have no problem with human clones. After all, there are such things as identical twins, but we do have a problem with producing them using a particular kind of technical means. In other words, when they're naturally occurring, it's fine, but this particular technical means of producing them, we have ethical concerns with, and so we ban a technology. It, however, doesn't work for most examples throughout history. I can come back to that if people want to later on, but most of the time it doesn't work. It only works when there's alignment between the goal of the law and the technology that's used to scope that law. Now here, the discussion at the beginning of the regulation, before it goes into the regulation itself, describes artificial intelligence as a fast evolving family of technologies, which instantly makes me skeptical this is a good regulatory object. So it also says that it's going to define it in a way that's future-proof and technology neutral. Now these terms have many different meanings. Not only my scholarship, but Jaap Coops and others have talked about what they might mean, and there's a whole array of meanings that have been given to them. But let's just assume for now that it means that as AI continues to evolve, so there's new methods and so forth, the regulation will continue to operate appropriately in line with its original goals, which is what I understand the goal of Annex 1 is. So I don't need to repeat the definition of AI because we've already had it. I can nitpick it. So I could say, for example, that it's only AI if the objectives of the system are human defined. So I could say, well, it's not AI if it's another computer system defining the objectives for a second system. So it's easy to sort of avoid being AI by playing around with that. I could give examples on the other side where it might be over-inclusive. But I don't necessarily want to play that game because I want to leave aside for now whether it's a question of fixing the definition and ask whether defining a technology or a family of technologies is the right way to scope a regulation like what Europe is proposing to do. So let me give an example, a concrete example in the regulation itself. So here's one term. The placing on the market, putting into service or use of an AI system that deploys subliminal techniques beyond a person's consciousness in order to materially distort a person's behaviour in a manner that causes or is likely to cause that person or another person physical or psychological harm is prohibited and so forth. Now, I want to imagine I'm only modifying that clause in one way. I'm going to delete the word AI. In other words, what I'm going to ban now is the placing on the market, putting into service or use of any system that deploys subliminal techniques beyond a person's consciousness and so forth. Now, it seems if I make that very subtle change, the goal of the regulation should be the same. In other words, if I find a way to do it that isn't an AI system, either because I play games with the definition or AI moves in directions we can't predict, I think I still shouldn't be allowed to deploy subliminal techniques beyond a person's consciousness in ways that harm them. So in other words, and I could make that same point. I actually went through Article 5 just as an example, and I could remove the word AI, and I think we still have a very good law. What about real-time biometric identification systems in publicly accessible spaces? Is that a particular technology we might want to regulate? It's getting closer in that it's something where I can actually see the problem with it as a technology rather than simply coincidences. But my question would be, do we have the same objections if instead of relying on that technology as defined in the Act, we had a person with perfect memory who watched a public camera and wrote down the names of everyone who went past? Now you might say, there's no such person. What are you talking about? Why worry? But we could certainly imagine in the future a person with some kind of memory drive implant that technically wouldn't fall within the definition of AI, but would raise exactly the same concerns about surveillance. So in other words, is our problem the technique, or is our problem in that case the outcome? What we need to do, remember, is to align the goal with the regulatory target because we don't know what technologies are coming. In other words, if we want to do the prohibition, should we prohibit certain kinds of law enforcement surveillance that identifies individuals in a crowded scale, some more general thing, or should we be focusing on the particular technology in the Act? So I think that's my 5 minutes, but I'm happy to continue that conversation in discussions.
Thank you so much, Lyria. This was perfectly on time, and I think a really rich set of remarks that also dovetailed nicely with the approach that Tatjana outlined earlier, and we'll go deeper into these definitional questions, conceptual questions, really, during our discussion. Our next panelist will be Alessandro Mantelero, who is a professor of private law and law and technology at the Polytechnic University of Turin, and also a Council of Europe scientific expert on AI. He's published very widely on the EU's regulation of digital technologies in general and data protection law in particular, and his scholarship often centers on fundamental rights, and that's also what he is going to focus on in his 5 minute remarks. Alessandro, the floor is yours.
Thank you, Thomas. I can share screen in order to stay in 5 minutes without any problem, and also to have a bit of context. Okay, so as mentioned also in the introduction, there is a sort of shift from the ethical to the law realm. And this is, of course, positive because we see an overlapping and proper overlapping between law and ethics in some documents. So it's important to set what is the role for ethics and what is the role for laws. But they are complementary. So what is important is not to miss one on the other. So not having a lot of ethics before and then a lot of rules now. It's important to maintain the idea that we have we need an holistic approach that take into account the social ethical dimension of the impact of AI and the legal dimension, the legal regulation without any overlapping. This is the first point. Second point, trustworthy AI. I'm very concerned about trustworthy. Is a non-legal terms. It was created by a high-level group and is based on the idea of trust. Trust is a marketing-based idea. There is a lot of literature on trust. I think that it's better to focus, as done by the proposal, on safety and fundamental rights. Also because we have a lot of experience in terms of regulation with regard to safety and fundamental rights. Third point, the risk-based model. This is the crucial point. All the regulation revolves around the idea of the risk and more specifically on the idea of high risk. So first of all, there is a decision to consider mainly high risk application. And this is something that is, of course, a political approach to AI. The second point is risk is a sort of mixed basket because we have both elements, product safety and fundamental rights. As mentioned several times by Tatjana, this regulation relies to a large extent on product safety approach, but we all remember that all the concern about the use of AI and also debate about the ethical, legal aspect of AI were about the impact on fundamental rights, on human rights, not only on safety. So I think that in the future discussion on this regulation, we should expand a bit this aspect on the protection of fundamental rights. Article 5, 7, 7.2, and 9, and the two annexes already mentioned, Annex 2 and 3, are on the risk-based model. With this different kind of approaches, I have also some comments about the fact that a lot of power is in the hand of the Commission, because the Commission can modify Article 3, Annex 3, for instance. And there was a decision to have a sort of closed list of high-risk application. This is different. If you compare Article 35, for instance, in GDPR, there's an open list of high-risk application. Here, the application that have a high risk are set by the law or by the Commission. But what is the main issue, I think? There is a missing element, how we assess the high risk. Because there is not in the document any kind of methodological criteria to assess the high risk. The entire document is based on the idea of high risk and set rules for high risk application without saying how we can assess high risk application and how we're assessed as a high risk application those that are in Annex 3. And by the way, we also consider an Annex 2, how, for instance, toy regulation is necessary an high risk application. There are many toys also equipped by AI that are not so high risk. So I think that this is the element that we should investigate more and elaborate more in the future round on this regulation, and to give a contribution from the academy, of course, this is our job. This is my last article on the human rights impact assessment in the context of AI. That is very practical to find a solution to set the threshold when the risk is high or not high. And this is the exercise that we do in the future. Is important because we talk about human rights or fundamental rights impact assessment a lot, but there is an absolute lack of methodology in the field of AI application. We have a lot of methodology in human rights impact assessment or fundamental rights impact assessment or large scale project, OIS plan, etc., but not in AI, where there are some specific aspects that we should consider. And with this, I ended my 5 minutes. Thank you.
Perfect. Thank you so much, Alessandro. And that really brings the fundamental rights perspective to the table, to which we'll come back also during the discussion, picking up on this theme of potential complementarity, but maybe also tension between different regulatory approaches as put forward in the AI proposal and the larger norms and values that frame European Union law and the regulation of law and technology. The next panelist will be Joanna Bryson, who is the professor of ethics and technology at the Hertie School of Governance in Berlin. And if you have been following the conversation about AI regulation, AI ethics, and the role of artificial intelligence in society, there's a very good chance that you've encountered her. She's also a very prominent voice on Twitter, weighing in a very informed way on various policy conversations, building on her background, not in law, but in computer science. Now she has a PhD on the very topical issue of intelligence by design, and she also doesn't shy away from hard normative questions, including on inequality. And I'll hand the floor over to her to make her 5-minute remarks on the EU's proposal for an AI regulation. Joanna, the floor is yours.
Well, thanks a lot. This is absolutely fantastic panel, and I'm a huge fan of the work happening in Pisa. And indeed, a huge fan of the work going into the various legislations, including the AI regulation, which is why I'm sitting in Berlin right now. Anyway, I really want to highlight one of the things that was said right at the beginning by Tatjana about that it is not too early. I was just arguing with Eric Schmidt about this. I was only in the comments, I was not in that panel. But I can't believe the kind of disinformation that is being circulated right now in the EU about things like it's too early, we don't know enough, you know, that you couldn't possibly regulate us. And in fact, what Andre said at the very beginning, well, of course we exist in regulation. I can take the time to say this because already the first two people have hit a couple of my main topics as well as Tatjana did. So thank you so much. It's been a fantastic thing. But I will actually highlight and extend a little bit of that. I am worried about any definition of artificial intelligence. And to an extent, I really think we should be thinking about software systems in general. So while I really love the strategies, and it's just the beautiful, elaborate effort, any place where you start drawing lines, then people are going to be trying to wheedle around those lines. And that also comes into the risk-based approach. I mean, to me, as somebody who holds two passports, neither of which apply in Berlin anymore, the American and British, I still think that one of the most dangerous things that's been done with AI is letting us like kittens. And that wasn't seen as a high-risk activity. It was just that there was somebody who had the innovation and insight to recognize that from looking at the publicly available information on Facebook and now on Twitter, we figured out how to do this on Twitter too, that you're able to recognize personality, big five personality types, and you're able to detect enough of the population that if you spend more resources on them, you can manipulate close elections. Okay. There was nothing about liking kittens that said let's start throwing elections. And also, it isn't that widely known. In fact, I think it's still controversial, but it's a theory in political science that when you have high inequality and high political polarization, you tend to get these close elections. So you could predict that there will be contexts in which you can manipulate society. So my main concerns are somewhat about these borders. I understand, of course, that they're being asked for, and I absolutely love the emphasis on that AI and software are products. They are products that provide services sometimes, but they are still the product of human processes, and we should be applying due diligence. If there's something, and I would like stuck in still, to be more explicit, just to say software is a product and that it is a manufactured product and all the extant obligations, just to be explicit about that, because right now it's still a little too implicit. Yes, it was said in the announcement, but let's be explicit because people are going to try to weasel out of these things. How many minutes do I have left? I have lots of nice points, but actually I'll let go because this is such a great conversation. I'm sure that we'll come back to anything I was saying.
Okay, great. Thanks a lot, Joanna. We'll hear next from Andrea Bertolini, who you've already seen at the beginning, who will be the only person on this panel who is actually in Pisa, in the room where it happens. And his remarks will build on his wide-ranging scholarship on AI regulation, often from a liability and risk management perspective that is informed by his background in private law. So back to you, Andrea.
I would like to focus my attention on Article 5, so the prohibited applications. And it says that, in particular, letter A and B of Article 5 say that the placing on the market, putting into service, or use of AI system that deploys subliminal techniques beyond the person's consciousness in order to materially distort a person's behavior in a manner that causes or is likely to cause that person or another person physical or psychological harm, and letter B basically specifying that it is also prohibited the placing on the market, the putting into service or use of AI system that exploits any of the vulnerabilities of a specific group of persons due to their age, physical or mental disability. Now, one very good and strong point of this legislation, I believe, is that it clearly states the preeminence of law and fundamental rights over technological development. I think we're all big fans of technological innovation and the benefits it might bring about, and yet we are concerned with putting the human being at the center. So protecting fundamental rights and maintaining that perspective is what the European Union has always claimed to be willing to do, and that is what having some prohibited practices is clearly displaying. However, there is a lot of uncertainty that resides with respect to what is to be deemed subliminal techniques. This recalls, for instance, debates that I was accustomed to as a child in the 1990s when people were talking about TV ads and how those could manipulate human will unconsciously. And so there is a lot of uncertainty with respect to what is to be understood with subliminal techniques. And even more, why only focusing on frail individuals? I'm a big fan of the protection of frail individuals. I think much needs to be done in that direction. But in some sense, we are all frail. We are all vulnerable. We can refer to the very interesting and persuasive book by Mark Kuckelberg from some years ago. I think it was 2013, on human being at risk, where he clearly states that and explains why we can say that every human being is frail and vulnerable in a way or the other. And this very much, I would say, works in exchange with advanced technologies, because if we only stop to thinking how the very notion of AI is defined in the technical literature, let's think of the Turing test, the ability of the machine to induce a human being interacting with it into thinking that he's actually acting and interacting with a human being rather than a machine. And this is the deceptive nature of AI-based technologies. Most of them being researched try to provide you that experience of something that is not truly real. AI cannot be your friend, and yet it can simulate being your friend. So this threshold is important. The fact that there are some practices that should not be allowed is very important. The fact that that has to do with user manipulation and deception is essential. Yet the threshold is not sufficiently clear and does not encompass a lot of uses of the AI that could be extremely problematic. In neuromarketing techniques, some applications at least, but also in inducing human beings into developing unjustified and therefore delusional emotional attachments to AI applications. So the fact that what is relevant is the fact that some physical or psychological pain is caused seems to be an excessively high threshold to meet that does not allow to encompass in the protection a number of situations that would instead be deserving of greater attention. In the end, I'd like to take the words of Christopher Boer in one of his recent, not very recent, but still recent article, where he says that basically AI is learning what we cannot resist. So this is a very important statement to make, I believe. AI is capable of exploiting our individual frailties and manipulate our perception of reality, and we should be very cautious about it. However, the path taken by the European Commission, despite commendable in the overall attempt, I don't think is satisfactory in the sense that it does not encompass a sufficient broad range of AI-based application that could cause some concerns because it places the threshold as being very high. That also makes it very hard for manufacturers to understand what it is that they can do and what they cannot do instead. Because if I were a manufacturer developing some form of AI-based application that also plays with the perception of the human user, reads his emotions, even eventually through facial recognition, but not solely through facial recognition, through a number of things, I would be left with strong uncertainty with respect to what I actually can do, because I don't know until it happens that that causes some physical or psychological harm. So again, this definition is somewhat going in the right direction, but not quite satisfactory and could be very problematic. And this could also be a source of liability. So creating this anti-uncertainty for the people that are actually developing technology is, I believe, extremely problematic, and some greater effort in defining what applications should be regarded as prohibited should be made. And I believe that it can be made in the next years before the possible eventual enactment of this regulation. Thank you.
Thanks a lot, Andrea. As you said, this is exactly the right moment to have this kind of conversation as the legislative process is gaining traction, and informed debates between academics and policymakers can push that kind of conversation forward, which is what we're trying to do with our final panelist, last but certainly not least, Sofia Rancordes, who is Professor of European and Comparative Public Law at the Faculty of Law of the University of Groningen, and has published widely on digital platforms, big tech, and often focuses on the constitutional and administrative law protections of citizens, often drawing on comparative and also theoretical approaches, including with a book on time, law, and change. Sofia, the floor is yours.
Thank you very much, Thomas. Thank you to the organizers. My 5 minutes will be focused on a very specific part of the EU AI regulation proposal, regulatory sandboxes, because this is also the topic that I have been working on, and it was partially the topic of my PhD, which was already some years ago, but back then no one was really talking about legal experiments and innovation. Now it seems to be one of the key areas of our interest. So the inclusion of experimental instruments in regulation in Title V of the proposal have been explained by the need to accommodate future developments and address their complexity. The inclusion of regulatory sandboxes fit within the aim to have future-proof instruments, to have innovation-friendly measures, and be resilient, offer a resilient response to disruption. And this is in line with with literature from different areas, not only from law, but mostly from from public policy and economics. In a way, I'll say that at first blush, it makes sense. I mean, I have written about this, so I wouldn't be able to say that the opposite myself. But the idea of having AI regulatory sandboxes needs to be taken with great care, because in principle, they can be great instruments to foster innovation, but it all depends on a number of factors. So it's not that the introduction of AI regulatory sandboxes has opened a wild west, as many would claim. It just has opened a way of actually advancing new measures and making sure that there is space for innovation, especially when it comes to small and medium enterprise, as Tatjana very well explained. This instrument also fits in within the so-called innovation principle, which is now part of the better regulation toolbox, as well as many other new perspectives that have been put forward by the European Commission. So I would like to address 2 key points. So the first one are more general remarks on the use of experimental instruments and innovation, because in general, experimental legal instruments have not been well received by lawyers, especially not in Europe. They are very well known in the US, where there are mixed results with the idea of experimenting and states as laboratories. They have also been used for controversial purposes, but they're just not applicable to Europe, because it's just very, very different. But in Europe, there are some use of experiments, and EU law hasn't been always very welcoming of this. So it comes as a surprise that now we do have regulatory sandboxes in this context. But at the same time, it's also an interesting surprise. And the second point is exactly what Title V actually allows. So regarding the first point, I would say that experimental regulations can take different forms. So you can have pilots, you can have phase-in implementation, as you had a little bit with the REACH system, but it was not, the focus there was on phase-in implementation. But experimental regulatory instruments allow in general for the derogation from rules. So basically, otherwise applicable rules are set aside for a temporary period, and the idea is to have like a sample group and a control group. In general, this has been criticized in many jurisdictions because due to the lack of legal certainty. The legal base for these experiments are always very clear. There is the risk of unequal treatment, and also the risk of disproportionate treatment. So this is also like one of the key aspects. But when we look at the countries that have been really like experimenting with legislation, namely France, for example, and Germany, we see that the problem of experiments with law are usually focused on methodology and implementation. So very often, the legislator thinks, well, we don't know much about this as experiments, but then there's not much thought being given to the way in which we actually draft these experiments. And this is also the risk for regulatory sandboxes. So regulatory sandboxes have been, especially implemented in fintech. That's where they are quite famous for. And they are a type of experiment that can also waive or derogate from legislation, just like regular experiments. But they can also offer many other options. They can also offer bespoke guidance. They can also offer customized implementation. We don't know yet whether this is the case for the UI, for the EU AI regulation. We don't know exactly what kind of regulatory sandboxes will be allowed. And this makes a huge difference, because if it is, if right now Title V only, launches like general measures, and one of the concerns here is whether this will give rise to fragmentation of the European approach to the regulation of AI, that we don't know yet, but this is a very important point. And I mean, of course, the creation of a coordination at European level could solve this, but we also need to know exactly what kind of regulatory sandboxes will be allowed. And I know my 5 minutes are running out, so I'll just conclude here by saying that the eligibility criteria, the modalities and the conditions of these experiments, of the sandbox, are essential. And this, of course, is usually regulated in implementation acts, but in general, this is part of the legal basis we need, the legality base we need for an experimental regulation. So I would say also in the final version of the act, it would be important to have this as well, because there is a big difference for the fragmentation of the market to see whether we have allow member states to derogate from existing rules, or we only allow them to experiment with bespoke guidance. So whether or not regulatory sandboxes can advance innovation or not, or whether they can contribute to the right implementation of the AI Act, it really depends on methodology and the kind of conditions and eligibility criteria we allow for the sandboxes. Thank you.
Thank you so much, Sophia, for your rich remarks on experimental regulation and the pros and cons of regulatory sandboxing. So this was really great, and we have a lot of issues on the table. And instead of giving the floor back to Tatjana directly to respond to all of them, I thought I would structure a little bit the conversation around certain themes that I thought emerged quite clearly. And the way I've been thinking about this issue is that this is really such a beautiful topic for law and technology research that asks crucial questions about how these technologies can or should be governed. So the way I would like to frame this would be to ask you what is being regulated, in what way, why, and with what effects. So that's the broad question that we're trying to address together. And I want to start with the what, building on what Lyria and Joanna said quite clearly, I think, that why is it that this is an AI regulation? Couldn't it be a software regulation? What is the right regulatory target here, and what difference does it make? So I would like Tatjana to come back on this issue, which is in part a definitional one, but it's also a conceptual one. And I couldn't, I somehow wondered, found myself wondering whether there was also a political element here. So much in the way in which businesses have had before the regulation interest to market everything they were doing as AI. Is there a regulatory response that also needs to say that this is now AI regulation because AI is such an important societal topic, whereas from a technical or regulatory technical perspective, other approaches might be more appropriate. So I would like to invite Tatjana to come in on that issue again, but everyone else feel free to weigh in as well.
First of all, thank you for hundreds of very good questions and interesting discussions. I think even 3 hours will be not enough to discuss. And yeah, I'll start with exactly this definition question, which, as you see already, even from our discussion, some say it's too broad, others say it's too narrow. And I think it will take us another 100 years to come up to any conclusion. And therefore, to operationally move on with regulation, we need to agree to some common ground, even it's not perfect. Again, if we go back to Article 3.1, about the definitions, of course, the first sentence says artificial intelligence system means software. Yeah, so software is a focus. But in order exactly to overcome this criticism that any software is the subject of regulation, yeah, then we say that it is developed with one of more techniques. Yeah, then this Annex 1 comes. But the third element, which is not less important, and I see the point by Lyria, for us here is the given set of objectives. Why did we add human-defined objectives? Because we wanted to say that still it's AI system is a result of human, human product. Yeah, so this is to underline that it's and I agree with you that there are certain techniques that could define objectives, so you tell it to one computer, another computer set the objective. But here the definition of objectives, which is not predefined, per se, this is the key here. So this objective, which would distinguish it from other techniques. or other systems. And then, of course, the last element is generate outputs such as content predictions, recommendations. So in that sense, I believe that actually the majority of people who look at the definition say it's too broad rather than too narrow. Yeah, but definitely the software is a key to here, as well as objectives, as I said, and Annex 1 as techniques. And Annex 1 should not be seen as so basically one of the also elements which mentioned as Annex 1 is statistical methods. Yeah, of course, statistical methods could be used both for AI systems and non-AI systems. That's why I cannot stress again that this is, let's say, you should not read just Article 3 separately from Annex 1 and the rest of the document. Yeah, so this is the holistic approach. And this is exactly the only way how we could square the circle, at least for the time being. You know, wait, I try to look both. Yeah, maybe for subliminal I leave for later because it's not to definition so much. Yeah.
Yeah, so we'll come back to
yes,
to the other issues.
Yes, for definition, I don't know what I go on. Yeah, it was not an easy choice, just to tell you the truth, because we tried to integrate the guidance by high-level group, but we also looked very much at the international arena. So what the debates have been taking place in the OECD, Council of Europe, etc. So yeah, and there are extremes. Some people say don't define AI at all. But then how do you then, exactly that comes back to another question, Valeria, like what is the subject of regulation? Yeah, so that's the dilemma which we needed to address. Yeah.
Great, thanks a lot. So I want to give both Joanna and then Valeria a chance to weigh in again on this issue. Joanna.
Okay. Well, thanks. And I support, the OECD definition has 50 signatories now, so I think it is a good place to start. Although my own favorite definition of AI is it's the subset of all the intelligent things that we're responsible for. The A is for artifact. But my second favorite is it's the subset of ICT, the communication technology that we over-identify with. And that actually, I think, is a sort of a opening into my understanding of where the AI reg sort of is sitting right now and where it could go before we finalize it. Actually, a lot of the things that I was worried about as somebody who's been very involved in AI ethics and trying just to communicate that it's software, that it's built by people, that we can audit it, that there's human processes involved, that we don't need to know what every little weight does in a deep learning system any more than we need to know what synapses do in bankers, right? I've been pushing that a long time. A lot of what I was worried about is come up in the DSA. As you mentioned, this beautiful suite of it's beautiful, and I hope it's robust. I'm slightly worried, of course, that somebody will shoehorn a gap in it. But I think it's really great. But anyway, the point, one of the great things about the DSA is that there is this built-in proportionality, that you ask companies to think about how hard, how likely are there to be bad things that come out with their stuff, and then you ask them to come up with remedies, and then as the EU does, and then the EU only checks their work, basically. They make the companies do the work proportional to how much of a threat they see themselves as likely to be. So again, if we cast this in a manufacturing liability, due diligence kind of framework, then we can get sort of automatic proportionality popping out, that people decide, is there any chance this could be misused, and they create appropriate levels of transparency to defend themselves. So the main things may be assuring people that there will be enforcement so that they have some kind of concern, and then clarifying, like I said, then you don't have to build in all these levels. You could say, we've done this. So I think the main point of the AI regulation, in a way, is, as Tatjana was highlighting, that it talks about these specific applications. And I don't know, I'm not a lawyer or a legislator, so I don't know how to make that beautiful, but I can tell you that I still have relations to the British. We had an interesting conversation between British and German regulators shortly after this was released here at the Hertie School. Anyway, you know what I mean. And one of the big things that came out was just, how do we make it palatable to the people of Stuttgart that we now can say exactly a fair way that children are going to be allocated to their schools. So before people with a lot of power were able to pull some strings, now they can't. Okay, and so that's turns out to be a lot of, you know, this expression, as you said, it's the public and the private, that has to be clear. How do we come to the algorithms that are no longer just something that are being executed by a human, but are now written down in software and can be exposed by, you know, freedom of information or something. So in my mind, that seems to be a lot of what the AI regulation is about. It's about humanizing the massive changes to society that the digital revolution have brought. Whereas a lot of the nitty gritty of how we're really going to regulate this is in the DSA.
Great, Luria?
Yeah, so I kind of wanted to come back to the sort of realpolitik point as well. So I think in some sense, it's not the European Commission's fault, my concerns about this, right? Because they were given a brief. They were told, do something, you know, regulate AI. And I think actually quite an admirable job from that starting place. But it's the classic response, I think, to new technologies. The classic legal response. Step one, define it. Step two, regulate it without sitting back and asking what for. So the one thing I quite liked, and this is again from Tatjana's presentation, was that linking to those 5 things. So complexity, opacity, unpredictability, autonomy, and data as being the sort of components of this. And I think that's a really useful breakdown step. I would actually just go even further. So in other words, what I would ask is, if you find something opaque, then that is a rationale for requiring transparency. And it doesn't actually matter if alongside that opaqueness, you also have autonomy or data or any of the other elements that we might associate with AI. The reason to make it transparent is the opacity, perhaps in line with the particular context, because obviously government decisions need to be transparent in a way that maybe dating apps don't, or something like that, right? So you can scale it to the context, but the point is you don't need all of them there to ask about that. My passion for this topic, I should say, I'm going to do an Australian example now, and this is very unfair because most of you might not know it. Has anyone heard of robo-debt? I don't know if the other panelists have heard of that. So robo-debt was this really dumb Australian idea. And the dumb Australian idea was, let's work out what people owe the government through an automated system, not AI, formulas, cross-matching data from tax and welfare data, and then let's have the system automatically generate the debt letter. And then people receive that debt letter and they have to pay the government because that's what the system's calculated. Now, it turns out, forget artificial intelligence, it was really artificial stupidity, because the formula doesn't work. So the formula the Australian government used to automatically generate these debt letters assumed that you are a sort of standard middle-class person whose income is flat, that your income in January is the same as March, is the same as November, is the same as December. The formula broke down the moment someone's income does this, which of course covers a lot of people who are on welfare. So therefore, most of the debt letters were in fact for debts not owed. Now, why do I mention this? It's because of the autonomy point, right? This is a problem with an autonomous system with no human in the loop, and that's bad. But when the government did it had a whole sort of AI ethical principles thing, and it launched them at an event that it lovingly called Tectonic, which was held in Canberra. And I went along to this event, and they were launching these ethics principles with these wonderful sounding things: AI shall do good, AI shall be environmentally friendly, whatever it all was. And I asked, well, at the time, the government was still promoting robo-debt. It hadn't cancelled the program yet. So I said, well, you know, you have these principles, why aren't they being applied to robo-debt? And the answer was, oh, that's not AI. We don't need to worry about ethics because it's not an AI system. The ethics is only for AI. And this was like COBOL and a database and cross-match data. It wasn't fancy. So I guess my concern comes from not a hypothetical place. It comes from, robo-debt, for those who do know the story, led to suicides. It was quite a tragic and horrible thing that happened in Australia. But the point is that if the definitional question and the scoping question comes down to not only a question of of how people might weave out of it and say this isn't AI and so forth. The question comes down to, what are we trying to do? And if we're trying to do something that is about something that is only AI, then I think you couldn't have a better definition. And I agree with starting with the OECD definition, and I've argued for that in other contexts as well, because we don't need 20 definitions floating around the world. We need to know what we're talking about. So I don't think it's a question of changing the definition. Like I said, I could nitpick that. I could nitpick any. I think I've nitpicked all of them in different places. But I do think it's important to make sure that if you could have gone back, the Commission had no option here, really. But if you could have gone back, ideally, to frame the legislation in a way that directly meets the challenges that the individual sections are responding to, rather than only those challenges when they intersect with some definition of AI, no matter how broad.
Great, thanks a lot. So let me transition, building on the interventions we've just heard, towards a related question. So I think there's a broad consensus within the European Union and on this panel that it's about regulating technologies to address societal concerns. And the question is how to do this, and we just discussed whether or not this focus on AI is apt or not to the task. A related problem is, of course, to then position AI regulation in relation to other regulatory instruments. And Tatjana's presentation pointed, of course, to the General Data Protection Regulation as the centerpiece of European data protection law. And Joanna, in her intervention, just highlighted the EU's proposal for the Digital Services Act, the DSA. So as Tatjana said, the Artificial Intelligence Act is part of a broad AI package. And then that package is part of a whole agenda around digital regulation with the Data Governance Act, the Digital Services Act, and the Digital Markets Act. So I guess the question I would like to ask to Tatjana and to all the other panelists is how to think about these different regulatory instruments and how to position them vis-a-vis each other. Because the tendency for lawyers is often to ask for clarity. So this is regulated by legislative instrument A, and this other issue is regulated by legislative instrument B. And the ideal, of course, is complementarity. So we want to have a regulatory system that addresses the societal concerns we have in a way that is operational, that provides a necessary degree of legal certainty, but also flexibility, which of course can be in tension. So the question is, what does this mean concretely for this AI regulation proposal? And maybe let's focus on the relationship to data protection law, where the AI proposal has this interesting Article 10 on data governance that addresses data concerns that the GDPR might not address in the same way. And at the same time, there is an article in the GDPR, Article 22, that also relates to automated decision-making. So there is at least some overlap, and the question is how that overlap is going to play out. And the related question would be how this proposal relates to other types of regulation of the digital economy, concretely platform regulation. So Tatjana, if you would like to come in on that, you're very welcome.
In 1 minute.
Else, please let me know.
Yeah, I'll try to be brief. I think it's a key question. I mean, what you already said, Thomas, and I'll try to be quick so other colleagues can intervene. The complementarity is the key here, and that's exactly the systemic thinking which we had. So we didn't want to regulate, for example, processing of personal data, which is subject to GDPR. But of course, we have to think that, like I already said 100 times, and I will repeat, that Artificial Intelligence Act is a product safety legislation, which applies to the placing on the market, putting into use of AI systems, irrespective, for example, whether the personal data is processed or not. So of course, if we have something to do with processing personal data, then it's subject to the GDPR. So AI Act doesn't really cancel GDPR, yes, it will be applied in addition. And for this matter, for example, there's a lot of also in an area of public, there is also law enforcement directive, yes, which applies to the processing of personal data. So this is both GDPR and law enforcement directive play. The only thing we have envisaged is Article 5.1D, if I remember correctly. It's a lex specialis of law enforcement directive. It's prohibition of real-time remote biometric identification. And in addition to what already in GDPR and LET, it's Article 52, which provides additional transparency obligations protections exactly, which are not, in our opinion, sufficiently spelled out in GDPR. Then what is also important to say, especially if you want to discuss in more detail GDPR, that Artificial Intelligence Act does not provide legal basis for data processing, except with 2 exceptions. It's Article 10 and Article 10.5, I think, processing of special categories of data for bias monitoring and correction, and Article 54, it's exactly for sandboxes, but for sandboxes I explain later. Moreover, also to enhance this complementarity with GDPR, we provide an option for member states to designate the data protection authorities as competent and market surveillance authorities for Annex 3 high-risk AI cases. So if they wish, that could be DPAs who take up this role. Yeah, and in terms of making it operational, Article 64 allows for DPAs to get access to documents. Be technical, but if you ask me, that's what I can tell you. But conceptually, on large, this is complementary, and each regulatory act has its own niche, so to say. With other digital files, there is a big complementarity also with Cybersecurity Act. So, for example, if you remember, the robustness cybersecurity is one big element where we have, for example, a presumption of conformity of AI systems, which certified under cybersecurity scheme. With Data Governance Act, our requirements don't apply to data intermediaries. Yeah, so I think important consideration logic of services, like I explained, while the Artificial Intelligence Act is based on the logic of product. But again, here, the different regulatory objectives, they still complement each other. And I think I'll stop here. I can go article by article on each proposal, but yeah, stop here.
Great, thanks a lot, Tatjana. So following up on that, as you clarified and emphasized during your presentation as well, this AI regulation proposal is a product, has a product safety framing, and that's different from a services-based framing, or different from a purely personal data-oriented framing as the GDPR has. And that, I think, leads to my next question, which also builds on Alessandro's presentation, which is about the role of fundamental rights for AI regulation, because the GDPR in part it has become so powerful because the Court of Justice drew on the fundamental rights to data protection and privacy already under the earlier Data Protection Directive, and developed this quite forceful jurisprudence which complicates transatlantic data flows and so forth. And that arguably was the case because there was this interplay between the secondary law instrument, first the Data Protection Directive, then the GDPR, and the fundamental rights that the EU guarantees under the EU Charter of Fundamental Rights. Now, if one reads the Artificial Intelligence Act proposal, it doesn't seem to be the case that fundamental rights are as prominent in the operative part, which is, I think, the point that Alessandro was making, who I would also invite to come in on this again. So I was curious about how you and the other panelists see this relationship between this proposal and fundamental rights framing, and how it relates to the risk-based approach for product safety that the proposal puts forward.
I may just quickly, and don't want to monopolize the discussion. I think in my personal reading, this actually should enhance that fundamental rights. And I think one of the, maybe Alessandro, somebody in the presentation actually mentioned that by including it together with safety, I think that's Alexandra's argument was, we also make it stronger. What we don't do in Artificial Intelligence Act, and this is maybe comes through the language, but we don't repeat what is already in the acquis on fundamental rights. Yeah, that's again builds on this principle of complementarity, because what we want to do is to make effective, yeah, or like to provide for operational means to, for example, enforce certain fundamental rights. But we of course don't list, it's still subject to already existing EU, for example, non-discrimination law or consumer protection law for that matter. So we provide, for example, and just to give example, Article 64 allows equality bodies to get access to documentation on high-risk AI system or request testing. Yeah, so this is something which, in principle, could allow for equality bodies to see if the system is biased. Yeah, so in that sense, it helps to enforce or enhance the enforcement of certain existing fundamental rights. So in my opinion, that's it was not an easy mix, and it's not a conventional mix, that's for sure. But we also didn't want to have this two separate dichotomy, you know, like we have safety legislation, which is part of internal market, and fundamental rights is something else. Actually, for us, it was important, and maybe we understand that sometimes this marriage, if you want to say, is not perfect, yes, but it's something, if we want to move on with this area of law, I think we felt that it's very important.
Right, Alessandro, do you want to add to this?
Yeah, first of all, of course, we are all happy about this initiative in terms of regulation in the field of AI that also benefits the safeguard fundamental rights. But such as all proposal, I think that the proposal can be better with a further elaboration on this point, for instance, because it's, as you mentioned several times, this product safety approach is not exactly what was expected by the community in terms of academic and social context. We expect more something that focus on the protection with regard to the risk of AI. And at the end, in this document, there is a lot in terms of certification, standards, etc., but from a product safety approach. I'm not so sure that product safety speaks the same language of fundamental rights protection. And in this sense, for instance, the exercise that is carried out by the Council of Europe is more focused on fundamental rights and has not the same constraints in terms, also, for instance, a point that I would like to have your feedback. This is assumed as a technically neutral approach in AI. But then in Annex 3, we have only a list, a closed list of techniques that are considered. So at the end, the definition of our AI is general and so neutral, but the application is not neutral, it's only for a specific case. So this is the concern that I have, that we are creating something that could be, is too focused on the idea of product liability. Product liability is based on closed system, like cars or planes, where every pieces can be assessed and put in the right place. With AI and the impact of the AI on society, it's much more difficult to have the same approach. And I think that a bit more problematic elaboration on this approach would be very useful in order to have an effective protection. And then, of course, the methodology is completely underdeveloped in this instrument, and I think that we cannot say the methodology is something that we developed in soft law instrument, because if the assessment of the risk is a core part, we cannot delegate to soft law instrument the core part of the regulation. These are some doubts. Thank you.
Great. So Sophia wants to follow up on Alessandro's point.
Yeah, I think Alessandro brought in a very important aspect, which is that this focus on product safety has actually also showed that we also have here an opposition between public and private dimensions. And the fact that the trust on the private dimension, the ability to rely on standard certification, also presupposes that this, this group of, this type of regulation will also take into account this key of fundamental rights, which is actually not true. We know from experience and from a number of scandals that actually this doesn't work. That standards and certificates have shown a number of failures. Just think of the PIP scandal, for example. So in that sense, this is actually something very important. The second element is that here we also have privatized much of the regulation by delegating so much power to the standards and certificates. And the question is not only a question of fundamental rights, because fundamental rights are mainly applicable in relationship with states, of course, but the thing is also a question of public values. And the discussion of public values is also briefly mentioned, I think in the preamble, there are some references to the values of the European Union, but I think it would be important to actually also explain a little bit more what kind of values, public values we expect, private, companies to also abide by, because I don't think this is totally entirely clear across the European Union. Also because this has been a very important discussion in the context of the regulation of platforms. The public values that, that we expect platforms to actually comply with are quite unclear. And so this is not only a question of fundamental rights, but also public values, of making sure that we are all on the same page when it comes to, to the regulation of AI, not only when it comes to, to product safety, but also more broadly other aspects which can also influence our perception of risk. And this has to do not only with fundamental rights, but also with what kind of values we want to prioritize, not only like internal market, of course, this is quite obvious, but also values that have to do, with the promotion of innovation, of sustainability, but also just in general, like autonomy of the individual. So this is, I think this part is a little bit missing. And I think it would be interesting to have also a bit of more of a public law dimension in this, AI regulation. And I think this is missing a little bit, perhaps due to the focus on product safety.
Great. Joanna is next in response to Alessandro and Sophia.
Well, yeah, it's a larger question. Actually, I'm not going to make a big comment. I want to make a question, but I will do a little bit of history. I got into this field just because I thought people were confused about AI. And so I started writing these little papers, and then people said, oh, you're doing ethics. And I was like, oh, I am, and it was, so we spent about a decade of computer scientists pulling ethics out of either, our behinds or the Stanford Encyclopedia. And then like about 2 or 3 years ago, when big people started noticing this was really a problem, people said, why aren't you doing human rights? And by and large, all the computer scientists said, oh, that makes sense, okay. But I understand now that there's a controversy that when companies are talking about ethics, they're talking about let's make something that's locally adjustable and that we can argue at length about. And when they talk about rights, when we talk about rights, it's because rights are well grounded in law. And so it's actually a sort of a platform forward. It is sort of a normatively, legally captured version of ethics. And I just wonder if that's actually a good talking point or not, because I'm still on the edge of this, despite having a chair that says I do ethics now.
Great. Let's give the floor back to Tatjana, who can respond to Alessandro, Sophia, and Joanna.
I don't know if I can respond quickly, but try to say that on methodology of the determination high risk, that's an open question, and why the closed list. We didn't want to go science fiction. What we tried to identify is the current use cases where we had evidence that AI system can be specific risk to fundamental rights and safety. And on this, we also elaborate quite intensively in the impact assessment. So both on methodology, how we selected it. So it was based actually on the research, what was based on the existing AI use cases, applications, which are now in proof of concept or on the market already. And that's why we also put it in Annex 3. So if the new use cases will emerge, or some use cases which are now non-high risk, but will become high risk, we will add it. That's why, as I said, Annex 3, it's not a list of some examples that's like what you say, closed list, but for this exact reason, to be operational. So what we try to do is maybe not a perfect, but still to achieve a certain balance between different interests of legal certainty, but also flexibility, and also to, let's say, dispel this myth of science fiction, of also. So, I mean, we have to be realistic what AI system at the moment can do or not do, and we identify the areas where applicable. So for fundamental rights, yes, we fully aware and we know that the logic of fundamental rights and the, let's say, background is completely different. But I think actually maybe it is a new way for us also to feel how to blend them both, and not to have a discussion only by fundamental rights lawyers, about the importance of fundamental rights, but then lacking operational instruments, how to bring them and enforce them. Yeah, it's like good to have, everybody should be happy and safe, yeah, but what does it mean, yeah? And in that sense, we can learn quite a lot from product legislation. And I want to say that we follow the logic of product legislation, but we not copy it one by one, yeah? And exactly what I said already many times, this putting these two elements together, and it's in a sense is an attempt to transcend the boundaries between, you know, disciplinary thinking. Here is only product safety, here is only liability, here is only fundamental rights, here's only personal data, yeah? So we try to interlink with different systems, and maybe it's not yet a perfect, but we have to start with something. And what just Jana said, you know, we can have debates for another 30 years, what is ethics, what are rights, you know, in the meanwhile, public interest will be defined by private companies. That's what we have seen in last years. And that's maybe just briefly to Sophia's comment. I would kind of disagree that there is no public interest. Maybe it's not spelled out like, you know, preamble number 1, public interest is, values are, but you of course can read and very much along with text, what are the public values? And for example, a lot of emphasis, that's actually a lot of public lawyers criticize that we put too much emphasis on the law enforcement and public authorities, and that we regulate more public authorities than private bodies. So in that sense, public interest is there, but that's why we think, for example, that the possibility to have infringement to fundamental rights, for example, if, for example, migration AI system is used, for example, in the law enforcement context, yeah, to determine certain entitlements to benefits or your right to residence, you know, is much more, it's higher risk level than if you have AI system which just suggests you which pictures are better, you know, how to improve your pictures, yes, and totally private concept, or if AI recommender system recommends you this song and not that song. So here, for that specific reason of protecting with certain public interest, we put quite a lot of emphasis on the public authorities. That's why public authorities are also within the scope of providers, and it was quite actually contested. So a lot of let's say, stakeholders and home and justice affairs, they wanted to have complete exclusion from the scope. They said you can regulate market, but not us. Yeah, and that's what was a big fighting line. Let's say, I mean, one of the big discussions in this context. Yeah, and I mean, I stop here, but I also have questions on regulatory sandboxes and other things. But I think, for purpose of time, I'll stop here. Okay. But happy to continue, of course, on any of these points.
Yes. So we just crossed the 2-hour mark with our event, and I think our panelists and our audience deserves a short 5-minute break. So we'll have a break now, and after the break we'll continue discussion. As you've seen throughout this conversation, we are addressing both the large questions about law and technology, ethics and AI, but also very concrete questions, which is the big benefit of having a proposal that allows us to zero in on Article 2, Article 10 and Article 67. And our audience has already given us very precise, very good question. So I would invite the audience to use the 5-minute break as you refresh yourself to also think about more questions that we're going to address in the final hour of our discussion. So we'll have a 5-minute break now until 12:08 European time. See you soon. Okay, welcome back. I hope you enjoyed this short break. We'll launch into the Q&A, but we'll first hear from our host in Pisa, Andrea, who would like to weigh in on the fundamental rights question as well.
Thomas, I think it's a very relevant point. I think that the fundamental rights question help us align the change of pace between discussing ethical approach to regulation. And one point that I try to stress all the time is that even when we discuss fundamental rights, it's binding regulation, and we can build upon a well-established interpretation of fundamental principles that are part of the constitutional values of the European Union and of its member states. So I think that provides a lot of guidance more than merely discussing an ethical approach, and really is a change of pace, something radically new. Now, I do believe that this aspect is not fully exploited, is not fully discussed and used within the current proposal and the current framework. I think much more needs to be done. And I think that, however, part of the gaps that I can see will be filled by judicial interpretation, or could be filled by judicial interpretation. So when we discuss frail individuals, for instance, when we discuss user manipulation, I think we can use the case law around human dignity and limits to freedom of self-determination as something that could provide concrete guidance in a number of cases, in a number of instances. Is that sufficient? It never is, actually. So we really need to make an additional effort, if possible, before any regulation is passed, to clarify certain aspects, to clarify certain definitions, to make certain thresholds clearer. But that should be the direction where we need to go. And really, I do believe that talking about fundamental rights allows us to build upon extensive literature, and even if there are methodological gaps, like Alessandro was highlighting before in his presentation, we have something to build upon. Whereas until we discuss very vaguely about ethics, that more than true ethical analysis is a form of soft law, well, then that is much more problematic. So I do see here a relevant change of pace.
Great, thanks a lot, Andrea. Let me build on that by bringing in two questions we got from the audience, which are within this fundamental rights framing. So the first one is from Christina Prifty, who is asking about this attempt to build on existing regulation that include ethical consideration, but then cover risks that emanate for health, safety, and fundamental rights, and thereby protecting the fundamental values behind that. And the question really is, if we have this conformity assessment for risks to health and safety, how does this relate to the fundamental rights framing? So in other words, if there's a risk to health and safety, isn't that always also a risk to fundamental rights, given that there's a right to health and human integrity, the right to safety, a little bit more controversial. So that's the first question. And the second one that goes, I think, in a similar direction by M.R. Leiser is about this idea that the AI regulation and the approach to regulation that the EU is putting forward here is somehow human-centric, and is human-centric if it has this fundamental rights framing at its core. But at the same time, as has been emphasized, the AI regulation is a product safety regulation. So this again tees up this question whether this regulation, this proposal, can be seen as a human-centric one if it's a product-centric one. So I think that gives us a lot to talk about, and I would invite Joanna to weigh in on the human-centric AI point first.
Thanks. Yeah. So again, speaking to this history, when I think of the alternative to human-centric, I think about a large number of people who think that humans are useless and we make lots of mistakes and destroy the planet, and that robots are our children and they're going to solve the problems. And there was an unholy link between that sort of post-humanism, transhumanism, which I'm on top of, not thinking that humanity is the entire purpose of the planet or something. But at the same time, all of our ethics, all of our morality, everything, all of our values, all our aesthetics, all have to do with the needs of this particular species of primates. And even the notion of trust, the whole thing about trustworthiness. Trust is a way that we let others like ourselves, peers like ourselves, off the hook a little bit. We don't try to micromanage them. And it doesn't make sense to talk about trusting, a machine itself. It talks about what we need to be doing, and that's the point of transparency, is communicating that trust between ourselves. So even when we talk about AI as a product rather than as an end goal, for some people that's already a form of human-centeredness. Now I'll release the floor. I'm sure that there's more to this in the law.
Okay, Lyria, following up.
Yeah, I also wanted to address this idea of human-centric, which I think is a really interesting and useful one. The Australian Human Rights Commission also has a report out on AI that is from the other side of the planet, so most people probably aren't aware of it. But one of the really interesting points they make is that, what has to budge? Is it our systems or is it the AI? And if in the sense it should be the AI. So giving the example of something like, okay, in administrative law and public law, the government has to give reasons for decisions. The use of an AI system should not be an excuse not to give reasons or not to give reasons of the same quality as you would have previously given. Similarly, organizations are liable when they cause harm. The fact that they had AI systems in place and this harm was sort of mediated through that system should not be a reason to escape liability. So another way, I suppose, to frame, I think, that human-centeredness is to say that existing rules, our own systems of governance, and what we say is important is something that AI systems have to adapt to us and our expectations rather than the other way around.
Great. Andrea, do you want to weigh in on this question too? And then Alessandro will be next.
Yes, thank you. Well, my point is really that, and in this, I heard there is a lot of disagreement on the importance of the human-centric approach. To mention one, Floridi, he was very critical about it. And I totally disagree. I am very much in favor of an anthropocentric approach. I do believe that it's the only approach that European Union can maintain based on its legal tradition. And I don't see any alternative model that I would like. And that doesn't entail stating that we have to not take care of climate change and relevant societal concerns. The two things are not in relation with one another. We need to have a strongly anthropocentric approach to technology, use technology for what it humanizes us most. So I'm very much concerned with those uses and those implications, and that's why I decided to focus on Article 5 and letter A and B in particular, but I'm very concerned with those uses of technology that could dehumanize users, and therefore, and I see that the European Union is getting this point right. I think it should do more, be more courageous in that sense, but that should really be the central focus, I believe.
Great, Alessandro?
Yeah, thank you. I comment a bit from a legal perspective, a legal scholar perspective. I think that when we draft a piece of law, we have to consider which language we want to use. Trustworthy, public good, human-centric are not so well defined in the legal language. So our notion that come from political science, from sociology, from ethics, etc. I think it is critical if in a legal text we use words that are not well defined in the legal context. Of course, we all agree that we would like to have a trustworthy AI, a human-centric AI, and we want the public good, etc. But the problem is that the legal category are based on elaboration that look back many years. And so, for instance, public good is not exactly a legal category, and public interest is a legal category. Human-centric is not a legal category. Fundamental rights or human rights is a legal category. So the problem is the language is not neutral, And a language from one field cannot copy and paste in another field. And this creates some critical issues when it becomes a piece of law. For this reason, I'm a bit concerned, not about the notion or the goal, but about the technique. I think there is, like in all first stage proposal, there is a lot to work on the manner in which we frame from the technical side this text. Thank you.
Great, Joanna is coming in here as well.
Yeah, I want to come back in. I just want to sort of highlight what both the previous speakers just said. That the point is not only about EU law, it is the only thing humans can do is to regulate each other. We have to be realistic about that. And I actually think one of the really important things that the EU is doing right now, it is the leading democratic regulatory organization. It's talking about scaling things at the human level. So I didn't quite say before, there's been kind of an unholy alliance between the interests of industry, which you can actually think of, and people, great philosophers like Petit and List have suggested that corporations and governments are a form of AI, right? So it's about pulling back from having really large actors and recentering on really being a democracy, a liberal democracy, where the efficacy of individuals matters. And I think that's part of why what the DMA, the Digital Markets Act, is trying to address, thinking about antitrust more coherently. So I think this is all about, it's human-centric on the human scale, because we're the ones that we're trying to control. We're trying to make sure that we don't behave badly. And I think that's what human-centeredness is. But I do appreciate that we need to be clear about that.
Great. So now we have the goal. Now we know what we are aiming for, and let's maybe focus now on some questions that will invite us to think about how to get there. So in other words, what kind of regulatory design is appropriate to achieve an appropriate means-ends balance? And we have great questions from the audience on these issues, and we can build on Tatjana's excellent presentation, which has highlighted these different features. So one feature is, of course, that there are certain AI practices that are seen as so dangerous that they need to be prohibited, which has been a long-standing debate also in AI ethics conversations, whether such red lines should be drawn or not. So one attendee asked us whether, given that there is this list in Article 5 of the proposal of prohibited AI practices, there's a need to include other issues that are not listed there, and how that kind of approach will relate both to national criminal law and to global regulation of technologies more broadly. So the focus here is on the ban of certain types of technology, and EURA wants to come in on this issue.
Yeah, I think actually the idea of red lines and the red lines that have been drawn in the EC proposal are actually quite good. I think it's a really good starting place. In other words, I do think it is appropriate for government to say there are certain things that shouldn't be done, and I think that can then give the public confidence that there is that process. In other words, I think that really matters. In terms of what the content of that is, I also think it's something that's going to very much change over time. Now, I don't think it's appropriate then to put in an annex, because I do think you want the process around actual changing the law here, right? So when you're going to prohibit something, I do think you actually want it to go before Parliament, the relevant entity in the relevant jurisdiction, rather than something that can be done at the back end. I also think there's a huge role here for public consultation. So if we go back to sort of really very old ideas around things like technology assessment, how do we get the public to think about in a conversational participatory way what the red line should be? In other words, should this simply be coming down from government, or should this be something where publics can actually debate and propose lists? And I think that in that context, the lists might be different in different jurisdictions, because what matters in Europe might be very different to what matters in Australia or the US or elsewhere. So then the question, which I liked, that follows from that is, well, how do you deal with this globally? I actually think, that we can. It is completely not a problem to say that certain things are okay in Australia, but not okay in Europe, and vice versa. And as long as companies are clear and the laws are clear about what can be done in different places, you can have systems that are designed for certain jurisdictions that wouldn't work in others. And in fact, we already have that. There are systems that are designed in China that clearly under the European regulation wouldn't be permitted. So I don't think that's a problem as long as it's clear. I don't think we have to say that we have to all agree because everything has to be global.
Great, thanks a lot. So that's on the prohibited list category, and which will, of course, create an incentive for the businesses, AI system providers, to avoid that category if they want to offer such services. And if we then go down the pyramid from the red area into the orange area, there are questions in the Q&A about the right approach to address high-risk AI. And I want to pose these questions to Tatjana and Alessandro, but as usual, everyone else should be invited to weigh in as well. So one attendee asks about a European Parliament resolution from last October, which called or gave recommendations for a civil liability regime for artificial intelligence, and whether that suggests that this AI Act proposal is more of a public law instrument, and how would that then relate to the to a potential civil liability regulation? And then there's a very concrete question by Leonard van Rompuy on Article 67, which is about compliant AI system, which still present a risk, which I think gets us to this question of when to classify AI as risky, whether we can do that ex ante by creating certain categories, or whether there needs to be a certain way of catching AI systems that we might not qualify as a high risk initially, but that still pose risks. And that's also the question, I think, that goes back to Alessandro, whether there's any value in using a concept such as trustworthiness to mediate this relationship between a risk-based approach and approaches that emphasize due diligence and accountability, which is also an issue that Joanna had raised earlier. So I first want to give the floor to Tatjana and then to the others.
Thanks. Just before I move to question on liability, just a quick question in response to Liria, that prohibited practices in Article 5, so they are subject to the full ordinary legislative procedure scrutiny involving the Parliament and the Council. So they are not in annexes. So this is the difference with high risk. So prohibited red lines are part of the full legislative procedure for amendment. So this is just to avoid any confusion, because you mentioned annexes and it's not part of annexes. Okay, so for question 7, it's a very good question. So as I mentioned in the beginning of my presentation, European Parliament adopted 2 legislative own initiative reports. This is very specific type of resolutions because they are based on Article 225 of the treaty, which actually indirect right of legislative initiative. You could call it as indirect right of a legislative initiative European Parliament. So basically what Parliament did, it's already proposed, so it said to Commission and simple courts, come with legislation, and this is the draft legislation which we want to see. In 2020, in October, Parliament adopted 2 of these resolutions, one on ethical framework and of AI and related technologies, and one on liability. This actually very much follows with the usual, or let's say common approach of European Union to safety, where we have a 2-pronged approach. First is related to safety, and then another to liability. So this is, for example, very different from United States, where main emphasis is on liability. So first, we let the product be on the market, and then if issues arise, we solve it through insurance and liability claims. So I wouldn't present it in a way as it was presented in the question about public and private enforcement. It's rather different it's complementary measures to ensure the safety and respect of certain values and rights of the product. So, and the EU actually, I mean, Commission follows the same approach. As I said, first we come up with artificial intelligence proposal, which is focusing on safety and liability rules, so revision of product liability directive and potentially additional rules on liability will be proposed in end of this year, beginning of the next year. And here the importance, so it was a conscious decision not to propose them together, but in stages, exactly to give a bit of time for debates on the definition of AI, the scope, the also, and basically also to make sure that these 2 two instruments are complementary. So we wanted to be a bit more advanced in the proposal with co-legislators to know what should be the next stage and not to start it at the same time. So the idea is that, for example, the specific characteristics of AI and definitions and the complementarity, they should be building on the same elements. So it's to ensure this coherence and consistency between different regulatory proposals. So just to summarize for the question on liability, yeah, so basically the Artificial Intelligence Act aims to, the main focus is to ensure safety and protection of fundamental rights, while the main focus of liability rules, forthcoming liability rules revision, will be to ensure compensation of harm if risk has materialized and damage has occurred. So even if we, with all the safety rules, we also understand that you cannot totally avoid harm or damage. Therefore, the liability rules will be this kind of post compensation mechanism. So yeah, this is, I guess, in short answers on resolution of parliament, but of course resolution of parliament very much, both resolutions and also resolution from 2017, of course, fed into the discussions in the commission. Just another point which I think also was mentioned by Alessandra, yes, Artificial Intelligence Act, and Andrea too, is a first step. Yeah, maybe it's not perfect step as babies when they start to walk, it's shaky step and maybe not perfect, but it's a first step in which we also need to take, yeah, in order to get into this area of law. And then in terms of public consultation, also just to highlight that there is now ongoing public consultation on the proposal. So everybody welcome to contribute to that. So it's in terms of getting public opinions on what has been proposed, in addition also to the, of course, by co-legislators. Then on Article 67, this article is indeed, as Thomas had said, aims to ensure that we don't freeze our assessment at the time when the AI system is put on the market. So yes, we put forward certain obligations or requirements like transparency or for high-risk systems. But of course, we also understand that the nature of AI technology is that they are subject to quite rapid modification, possible rapid modifications. Therefore, this whole section gives a possibility for national authorities to have instruments which will make sure that we have a continuous possibility to assess this type of risks which the product might develop. Yeah, I wouldn't call it necessarily catch-all, because of course, if you look at Article 67, it specifically refers to Article 65 evaluation, and this evaluation is related to specific instrument, which is this market surveillance regulation, and it relates specifically to the risk to the health and safety and protection of fundamental rights. So it is indeed an instrument to make sure that if the product has been substantially modified, and as a result, for example, now it's not only transparency risk, but high risk, then this will be also subject to possible corrective measures of the surveillance authorities.
Great, thanks a lot, Tatjana, for doing all the heavy lifting. I think Andrea wants to weigh in on the liability issue as well.
Yes, thank you. As you know, civil liability is one of my obsessions, and really, I do believe that it was a really good move of the European Union not to discuss liability in this first proposal. I'm a bit concerned with the proposal that we will get at the end of the year or early 2022 for one specific reason. First, I will say why I'm happy it's not there. And on this point, we discussed with Alessandro in other occasions. It's very hard to regulate advanced technologies unitarily. And I do believe that if you want to set the floor based on more general consideration or fundamental rights-based consideration, or saying what is licit and what is not licit, there you can effectively try to come up with a broad umbrella definition of artificial intelligence and try to regulate it unitarily, at least with respect to certain specific aspects, like those that are tackled by the current proposal. I'm also a big fan of the fact of separating product safety regulation from product liability, In my earliest research in advanced technologies, I always said that we have a quite efficient body of legislation on product safety at European level that can be further improved and refined, and that will provide essential solutions in a varied array of domains. And liability should just be focused on providing compensation exposed when something goes wrong, like Tatjana was saying. However, there is an essential difference, and that is the primary reason why I'm very happy of the separation, and yet I'm a bit hesitant about what could come by the end of the year. Something that should not happen is to try to regulate civil liability unitarily, because AI is way too broad a notion. It encompasses a toothbrush, a smartphone application, fintech applications, care robots, chatbots, expert system used in the medical malpractice, and all these things up until today belong to different domains that are separately regulated with respect to liability. And the technical element, the technological element of AI is not so strong as to justify addressing these separate fields of liability unitarily. We're not replicating a general rules of tort. We are here trying to address, or we should be trying to address, specific liability concerns that arise in the medical malpractice that are not the same to those that arise in consumer products or in financial markets. So there, on liability, having this broad and all-encompassing approach to regulation, having a single piece of legislation even, I think would be most problematic. In some cases, the incentives would be right. In other cases, they would be absolutely unjustified. If we look into the proposal by the European Parliament from the last October that was mentioned in the question, the greatest concern I have is that, for instance, we could have multiple operators as potentially responsible parties. And in a very simple example, let's say a medical doctor uses an AI-based system in his medical profession, and there is a negative outcome. He could be held strictly responsible for that harm because he used the AI-based system and then qualifies as operator of the AI system, being in control of the AI system. And nowadays, at European member states level, there have been made efforts in order to attempt to shield responsibility away from medical practitioners, eventually to medical structures such as hospitals. That was the case in Italy with specific legislation, but it is the case in many other member states. Now, the rule that holds the operator responsible, that probably works very well as it does today for drones, would be extremely detrimental in this case, would disfavor the uptake of technology, because a medical doctor that decides to use the AI-based system would qualify as the operator of the AI-based system and thence be held responsible on a strict liability basis, whereas his colleague that doesn't use the AI-based system would not be held strictly responsible. So this is just one specific example. And of course, if you apply the same rationale to a different setting, a different use case, that changes the analysis radically. So it's important that a piece of legislation like the one that we are discussing today, that really attempts to have a very broad spectrum of application, does not address responsibility, does not address civil liability. I am a bit concerned that anyway the draft proposal that we will get on liability will still maintain this extremely broad scope of application. Driverless cars are not the same thing as expert systems used in medical malpractice or fintech application and so on and so forth. While we can regulate certain aspects, like we did in the current proposal, and even trace some clear red lines that eventually need to be improved, we cannot regulate in the same way liability. So I'm very happy that liability wasn't included in the current proposal.
Thanks a lot, Andrea. So we are still discussing different options, how to regulate AI to achieve the societal objectives that the European lawmakers are trying to put forward, ideally in the interest of the European people. One question that I raised earlier and that I would like to pose to Alessandro is about the role of the concept of trustworthiness and how that relates to related concepts around reliability and authenticity, and how he would view this concept and its usefulness in relation to the fundamental rights framing that he advocated for. Alessandro.
Thank you. Just only a brief comment about Andrea's last consideration. I fully agree. And I want only to add that typically liability is an industrial policy topic. So you allocate liability according to your industrial agenda and strategy. So for this reason, it's not neutral. It cannot be addressed in the same way for all the application, because of course has an impact on development and the cost of the development of AI. So it's a very sensitive topic that needs different nuance in order to be fully addressed. And regarding trustworthy, as I mentioned before, I'm not so happy about the terms, but not from a legal perspective, no, the notion in per se. As I mentioned in the question, trustworthy can be also considered as a form of transparency, accountability, and security, etc. From my perspective, this means that we have other words that are more appropriate than trustworthy and more legal than trustworthy. And but I agree with the comments that of course there is room for trustworthy. It depends only what we want to say. One thing that I want to add in this regard is that one point that is very crucial for an industry is to know if its application is under Annex 3 or not. And this is, of course, very important from a trustworthy perspective, because as an industry, I need to know what is the future, where I can invest. And right now, I think there is a lack of clear transparency about this step, because it says that the list of application articles in Annex 3 are set by the Commission. But again, the lack of a methodology does not make possible to understand how these categories are selected. There are only some criteria, but are not any description, methodological description how these criteria are operationalized in order to include or not something in the Annex 3. Of course, this is a very important point, I think, because in the industry and companies need to know what are the criteria and how these criteria are methodologically applied to include something in the Annex 3 and so apply this regulation or not. And I think this is an element of trustworthy in AI, if you want, from a company perspective. Thank you.
Thanks a lot, Alessandro. So as the last set of questions within the regulatory design rubric, we have one very specific question about the relationship between this AI regulation proposal, which is a new kind of product safety regulation, to existing old style safety regulation, for example, car legislation. So Tatjana will clarify that issue. And I want to couple that issue, which is very precise about Article 2, Paragraph 2 in Recital 29, with this long-standing debate about the alleged need to have some kind of legal personality for artificial intelligence. And I saw an eye roll on the panels, and maybe among the panelists, and maybe also among the audience. And the audience member asked the question, put it this way: is this the end of this debate? But as the EU is pushing forward a regulatory proposal that clearly does not rely on any kind of legal personality for the AI systems that are being used by the humans and their companies that deploy them. So Tatjana first, and then Joanna on legal personality.
Okay, good. I'll try quickly on Car's question. It is covered, but like I explained, it's a different legal technique. So for new legislative framework legislation, like medical devices, for example, the requirements of the Artificial Intelligence Acts will be directly complementary. For cars, for example, which follows old approach legislation, at the end of Act, you see a number of articles which are providing delegations to amendments of specific old approach legislation. So basically, with amendments, empowerments provide a provision which basically say that while amending type approval legislation on cars, take into consideration the requirements of Artificial Intelligence Act. So the short answer, it's applicable to the cars, but in indirect manner. And as I explained, it's just a legal technique that it cannot be like directly applicable, these provisions of these regulations, to, for example, the type approval legislation, but they are covered. For that reason, you find the mobility sector related all approach legislation listed in Annex 2, and these empowerment provisions at the end of the legislation to change the provisions. Yeah, and I leave favorite questions to legal personality, Tatjana. Of course, I could jump in on as well, and the debates in Parliament in 2017, but I leave it to you.
Oh, well, now I want to hear what happened in Parliament in 2017. But one thing that happened in 2017 was that I wrote a paper about this with two leading law experts. So first of all, why would you even think about doing legal personality for AI? Well, it's not that crazy because there's legal personality for corporations, there's legal personality now for rivers. In India, there's legal personality for idols. One thing that all these have in common is that there's humans that are utterly dependent on something that cannot be replaced. So it's unique wooden historic idols in India. It's a river that people's livelihoods depend on and that's considered holy to them, but also that, you know, really, if you destroy it, there's no way to get a river back. And the whole point of digital artifacts is that you can replace them very easily. Now, one of the things that's happened recently with the legal personality is the reason we have this, it's called a legal fiction. It makes it a little easier to create contracts. So, for example, between corporations. But with the overextension of it, so that people don't have enough of, there's no human that has skin in the game, then you get corruption. That's when you get something called a shell company. And you see, for example, a lot of real estate projects that are set up only to go bankrupt, to do kinds of money laundering. So that's the kind of problem you have when you overextend legal personality. And the point is that AI as a digital artifact would be the limit case of a shell company, it'd be the ultimate shell company. And so actually with the paper that we wrote in 2017, addressing the European Parliament's interest in this, a lot of which came from legitimate concerns about liability. So the concerns were that, like, you know, what if we make autonomous cars in Europe? How are we going to handle the fact that Google and Apple, who are making more money than they can legally spend, and so that's why I think transnational taxation is also a big issue here, that they're saying, oh, sure, we'll be liable for our cars. And if you're Renault, then you don't have the money sitting around that Apple and Google have sitting around for these kinds of risks. So yes, we have to handle liability. We have to handle the risks that European companies take, but legal personality is just not the right way. And I would guess the fact that we now have this separate legislation from the AI legislation, the liability one, it is a good sign that the European Parliament have got this. They understand this now, or the Commission do at least.
Great. So after we've criticized and discussed this proposal, let's imagine we enter a world in which this proposal might become law. And the question is, what would that look like? How would it relate to other regulatory initiatives? We have a question on this with regard to cybersecurity legislation. And what does that mean for the relationship between law and technology? So that invites us to come back to Sophia's intervention at the very beginning that highlighted this regulatory technology of regulatory sandboxes that tries to reconcile the desire for innovation and for flexibility with the need to have transparency about the practices that happen in the sandbox. And the question then becomes what to do with that information. Is there then a need to, how can that be fed back into the regulatory environment that has been created? In the context of European Union law, it was also clear, I think, in Tatjana's presentation, there's always this question of how much entrenchment there is. So once you have a regulation in place, is there any way to change it? And as Sant'Anna explained, that sometimes that's what necessitates the need for all these annexes, which might be easier to change to be able to adapt over time. So I would invite Sophia and Tatjana to reflect on this theme of regulatory flexibility and sandboxing within the AI proposal, and then we'll move on to how the proposal might change and how it relates to other legislative instruments. Sophia and then Tatjana.
Thank you. I mean, I actually would like to, I don't know if I came across as critical, but I actually would like to say that I'm actually quite positive about the inclusion of regulatory sandboxes. But of course, the future and the contribution of sandbox has to do a lot with the way in which it will be implemented. And so in that sense, I do think that they are crucial for for the creation of room for flexibility, and they can really help ensure that there is room for adaptation, for regulatory anticipation, I would say. But of course, it will depend on the coordination between the EU level and national member states. Because the thing is, we shouldn't forget that there are already some national regulatory sandboxes. Norway has one. France has also some regulatory sandbox. The UK, Germany, many of them in the area of AI. So I think, in a sense, when it comes to the implementation, I think it's important for the EU level to learn from national initiatives, even though they are very often focused on data protection and ensuring that that small companies actually are helped along. So in that sense, I think that there is some room. But when it comes to flexibility, I think regulatory sandboxes do provide this flexibility to ensure that when AI systems change, or when there are new and unforeseen innovations, that there is room for that. So I think that is actually crucial. My only critical point is basically that we have learned from different legal experiments that when you actually leave the legal basis too broad, and you allow for too many possible different outcomes when it comes to experimentation, that this can be taken advantage of, and that can be very difficult to evaluate their success. So in that sense, in order to guarantee that this flexibility is really totally embraced and leads to the best outcomes possible, I think it's important to actually reflect upon methodology and also upon the way in which the delegated act will be shaped to ensure that the flexibility doesn't turn into an abuse of this opportunity for experimentation. But of course, Tatjana probably knows, she can tell us much more on how what the vision is of the European Commission.
Well, that's actually a very good question, and it's a pity that we don't have a lot of time to discuss it, because it's a bit of a beaten track what we usually discuss: definition, scope, high risk. And I think it's actually one of the elements what I really believe, and what we try with colleagues to bring innovation. As Sophia has mentioned, actually there are some discussion text like experimentation clauses in current legislation, but actually there is no existing EU legislation which has similar provision on regulatory sandboxes. Yeah, so we understand both responsibility and experiment that we put forward in terms of regulation. And actually these regulatory sandboxes have been quite intensively asked by member states, because saying that with technologies as AI, we really need a bit of more experimentation room. And as Sophia had said, there are basically two options. One's to see as regulatory sandboxes as a kind of escape space where there are rules are not applicable. And another one is to receive guidance, especially for smaller companies who don't have or public authorities who don't have sufficient, let's say, resources to hire, a different set of lawyers who will explain all this complementarity, etc. So we are thinking more in the line of second option. And just to say that this was also quite debated, and it was controversial articles. We initially had, I think, about 10 articles in regulatory sandboxes, and we ended up with 2. One, as Sophia had correctly said, like 53, is more to give legal basis for further actions, to leave it actually to member states to develop these methodologies and guidelines under the kind of guidance of European Union, but also not to us to set exact rules as yet. I think we need a bit of time. And this is also related to another thing, which is not part of regulation, but again, it's part of a coordinated plan. EU starts this year 2 very big initiatives, one called under Digital Europe program. One is related to testing and experimentation facilities. So there will be established and co-financed by EU 6 large testing experimentation facilities on AI, for example, to create a testing environment next to real and health or road. And another very big aspect, it will be quite a lot of digital innovation hubs, the European digital innovation hubs, and at least one digital innovation hub in each member state must be on AI. And they of course have a bit different functions, but what we also wanted to do is first to see the first results from these 2 co-financed, let's say, experiments on experimentation. So, and then in function of how these 2 instruments function, then try to define more precisely how this testing experimentation facilities will work. In terms of exceptions from existing legislation, Article 54 provides a legal basis for data processing. So this is only a small exception from the GDPR. which allows for further processing of personal data in the sandboxes for the development of certain AI system in the public interest. And here again, public interest comes into play. So not for any kind of purpose, but for the public interest. So we tried to actually provide, in terms of regulatory drafting or legal drafting, to keep these two articles exactly for this reason. So 53 is a legal basis for further action, and which will also give us a bit of more time to reflect how these instruments and the Digital Europe program work. That's why I again stress that about a lot of complementarity about this coordinated plan and legislative action. We don't want to do the same things, and we want to build also from the experiences as measures which are not necessarily legislative in pure sense. So, but this is very interesting topic, and it's also an experiment in itself within this big experiment on regulating on AI.
Indeed, thanks a lot for sharing that experience from the inside of the European Commission with us. And there are two more questions, I think, directly to you on this issue that I want to ask, and then we'll have a final set of questions on transnationality within the remaining time. So the two questions are about what this will look like in the end and how it relates to other regulatory initiatives. So Maria Camilla Fiazza asks, how much room is there for change? What might this proposal look like once it's an actual regulation? And I think the harshest way of asking this question would be, what would need to change for the Commission to pull this proposal, because the Parliament and the Council shift completely from their approach? So is it really just about adding some recitals or adding certain high-risk systems to the list of high-risk systems, or is there more room for change also on the conceptual side? And the other question by Simone Pieri is about the relationship between the AI regulation proposal and the existing directive on security of network and information systems, and the proposal, which I think again goes back to this question of how to navigate that the EU is modifying its digital regulatory frameworks at the same time.
Okay, the first question, you need to be a prophet, but I'm not, so but I'll try to answer. I mean, of course, reading what Parliament has asked, I mean, we are very in the beginning, so the proposal was put forward in April, so we are really just in the beginning of the debates with co-legislators. But my reflections would be based on the, of course, the inputs we received, for example, from Parliament and Council, from the resolutions adopted by Parliament. So I think on the big lines, there is quite general alignment, also from the reactions we received from individual members of European Parliament or Council members. I mean, I think nobody tells us that it's completely wrong direction, you know, it's more like, yes, I mean, maybe it's not perfect, but you are in the right kind of direction. Yeah, so it gives a bit hope that it could be. But at the same time, for example, discussions on prohibited use cases, on biometrics, I mean, that could trigger and last, you know, so this is difficult to say, but we hope, I mean, at least Slovenian presidency in the Council was very determined to have some like Council compromises by end of the year, but I mean, maybe it's too wishful thinking. We have to see. I think that makes it also interesting topic to follow. You know, I think it's very dynamic, and we'll see a lot of debates and discussions. I mean, from our side, probably the real negotiations will start in the autumn. Then the Parliament appoints the relevant committees and rapporteur, and Council already appointed the Council Working Party, which is Council Working Party on telecommunications. But also, for example, Economic and Social Committee also drafts opinions. So two opinions, one on coordinated plan and one on the regulatory proposal. So they also have debates inside. So there are quite a lot of happening, I would say, on this, but exact outcome, I mean, from side of Commission, we cannot amend it now, but of course, co-legislators can bring in amendments and bring it in. So this is something to come. About the relationship with other pieces of legislation, I think since we have 4 minutes, I just be short. Again, we'll try to ensure complementarity, and of course, it will relate to the requirement 5 on robustness and security of systems, and there we'll see how this could be complemented. But especially in terms of requirements, just to maybe as my last intervention, and I will stop here, is just the requirements are still quite high level, you know, so they still need to be operationalized. And I spoke a lot about standards, but not everything will be operationalized through standards. Yeah, and it's maybe comes back to our earlier debate on the fundamental rights. So there will be certain guidance, there will be certain further follow-up, potentially even legislative acts. I mean, it's not excluded, it's not yet exactly planned, but so basically this is still quite high level, you know, like almost like constitutional level type of requirements, which will then be operationalized for further stages of discussions. And standards is one element, but it's not maybe the only element how these requirements will be operationalized. And yeah, I'll stop here.
Great, thanks a lot, Tatjana. So within the last 3 minutes that we have, and maybe 5, compensating for the break, the last set of questions that we can bundle together is about the transnational dimensions. After all, this event was under the large umbrella theme of EU rules AI, and the question is, well, in Europe or globally, there's this element of extraterritorial application. Taking a page out of the GDPR playbook, the AI Act proposes that it would apply to any kind of AI system that is providing services in the EU, regardless of from where it is being provided, which will, of course, also create an enforcement problem of the kind that GDPR and data protection lawyers are quite familiar with. But then there's this other question, how this proposal will impact standard setting in AI governance venues more broadly, as in the IEEE, for example, and AI regulation in other jurisdictions. There's one question from an audience member about comparable initiatives in other countries and how they grapple with these difficult questions about a fundamental rights-based approach, a human rights-centered approach, a risk-based approach. So what I would like to do is to give every one of our panelists a chance to weigh in on these transnational dimensions with 1 minute each, if possible, and we'll go in reverse order. So we'll start with Sophia, then Andrea, and so forth. So Sophia first.
So I think the transnational dimension is probably one of the key dimensions here, because we have to make sure that when it comes to regulation, the existence of different standards will not actually be the way in which this regulation will be undermined. Because the thing is, right now we have that already, the problem in consumer regulation. As far as I know, I'm a consumer expert, but it's something that I hear very often from consumer law colleagues. So in this sense, I think it is important to make sure that when we have, this new piece of legislation approved, that we also ensure that if we are going to put forward values, European values, that also it's clear how they're going to interact with different dimensions, with the transnational dimension, because of course we cannot impose our European values on everyone, but we need to make sure that at least we agree upon a minimum level, because otherwise I think that we will definitely be undermining the future of the AI Act. Thank you.
Great. Andrea, do you want to weigh in on this as well?
Well, here, this is exactly catching the sense of the title of this event today, in the sense that Europe is really after the Brussels effect. Europe is really trying to rule and rock the AI world beyond its own borders by taking the lead in regulating artificial intelligence. Whether that will succeed is an entirely different story. One aspect and one fundamental caveat, however, is that when we discuss fundamental rights, there are interpretations of fundamental rights and principles that differentiate in different countries, different jurisdictions substantially one from the other. There are some differences within European borders, but even more beyond those. So, for instance, the relationship between self-determination and human dignity in European bioethics is very differently declined in North American bioethics. So when we start discussing the application of fundamental rights, differences will emerge and will be evident. And I don't think that the Brussels effect will extend to those as well. So yes, there is indeed, this is the reason why the European Union is trying to make this move. Will it be successful? I really don't know. It very much depends on the final layout of this proposed legislation. But there are some differences, some divergences that at global level will not be filled, I believe.
Great, thanks a lot, Andrea. Joanna?
Yeah, sorry about that. Right. So yeah, I want to once again critique something that Eric Schmidt has been going around saying recently, that wouldn't it be nice if you guys just regulated your own AI? The AI that is being produced on the American West Coast is being produced by Europeans, by Asians, by people from all over the world, running to this under-regulated space in which they can do these kinds of things and raise this kind of money. So first of all, we are regulating our own AI. Secondly, what the GDPR has shown is that we are also able to say, and this is similar to human rights, that we can control how these products are applied within our borders, to humans operating within our borders. And this is an obligation that we defend the human rights. That's an obligation every country has signed up to. So we're doing that with the GDPR, and I think it's completely sensible that we can continue to do that with AI. And I want to say one last thing, which is that diversity matters. The variation Andrea was just talking about, it's important that we have these different kinds of interpretation, because that's where innovation comes from. Innovation comes from people having lots of different ideas and testing them out. So while it's been a huge strength of the GDPR that we've put 500 million people together so that we're a big enough market that people will negotiate with us, at the same time, I think in the end, we don't want to have fewer than 5 or 6. I think it'd be great to have 10 or 20 experiments in how do you regulate these kinds of products.
Great, thanks a lot, Alessandro.
From a not only European Union Center perspective, I think that we should consider also the experience, the ongoing work at the CAI, the Council of Europe ad hoc committee on artificial intelligence, that is working on a framework convention on AI. With an approach that is quite different and not so focused on product liability and more focused on fundamental rights, democracy, and rule of law. And the experience of Convention 108, for instance, in the field of data protection, Convention of the Council of Europe, is a significant experience that paved the way for many other regulations around the world, not only in Europe. So I think that this comparison, if you want, between the two proposals, I think that also highlights a point that if we rely so much on product liability and the internal market, European market rules of product liability, maybe this product is not so easy to be internationalized, to be exported. If you ground the proposal more on general principle and fundamental rights, this is easier to be exported. At the end, this is the reason of the success of the GDPR. And so I think that the Commission has made a great work in, and also it's quite brief, you can say it is a great act to decide to fix some rules in this field. But at the same time, is a very big challenge to be addressed. And for this reason, I think that this discussion in the academia are very useful because, of course, there are participation, etc. But our role as academia is to contribute actively in the shaping of the regulation. Although this makes that sometimes we are critical, but it's critical in a positive sense.
Great, thanks a lot. And Lyria is next with the perspective from Australia, where it's getting very late. Thanks a lot for bearing with us.
Yeah, sorry, I'm probably getting less coherent over time. But I suppose what I can add to this question is the perspective of a small and relatively insignificant jurisdiction. So Australia plays a role in things like ISO standards and so forth. And so we get a say in the kind of rules that come out of those sort of international processes, and we're in the OECD and other places too. And so some things can be internationalized through those kind of coordination mechanisms. But the conversations in Australia and the priorities for Australian people are going to be quite different to what they look like in Europe. There will be absolutely some commonalities. I think human rights has been a really good example of that. But in terms of where people want legislation, where people want regulation, will be different. The Australian experience is going to be shaped quite heavily by something like robo-debt, because that's what the public is currently talking about, which means that the conversation will go beyond AI in some ways and will also be more around the public law and the government's obligations for these systems. And that might be more where people are concerned, or where people want the government to respond and pass new laws and so forth. So I think we should allow for that. I actually think that, it's completely okay to say, different jurisdictions will decide to put, to use the words from earlier, what happens in their borders. The only difference, I think, is that whereas Europe can talk about a sort of Brussels effect and the whole world meeting that, Australia has a very different set of options. And if you look at what happened recently, whereas the Australian government was passing new news media bargaining codes, and I'm not going to get into the detail of that, but literally Facebook said, fine, we're walking. You know, we won't let news be published in Australia. We'll just walk. And so for smaller jurisdictions, I think the issue can be quite different. It's much more likely that companies will simply walk away. And that puts a very different, I think, challenge to how we ensure that different democratic publics get a say over what technology does in their jurisdiction.
Great, thanks a lot, Lyria. And Tatjana, with final thoughts in 1 minute.
Yeah, I'll try to be brief. So first on Brussels effect and global reach, I think we're in very different situation when at the time the GDPR was proposed. So the dynamic will be different. I mean, of course, we hope for that EU will, of course, has this global impact, but I personally think it's quite different dynamics. So it will not definitely follow the same. I want to underline to Alessandro, or come back to this. I mean, we are not following product liability framework. I mean, we are inspired by product safety legislation, but not product liability necessarily. And on that point, I understand that there are a lot of fans of GDPR, but GDPR also has shortcomings. Yeah, and our, especially, for example, in terms of implementation and lack of guidance, how to interpret certain provisions. And what we try to do in this act to learn from the both worlds. So on one hand, product safety legislation, on the other hand, also about thinking about enforcement and operationalization of certain things. Yes, you may dislike, for example, Annex 3 as operationalization of Article 6. But on the other hand, for the companies, for example, yes, it makes it much more clear, am I in Annex 3 or not, you know, so it doesn't leave me large discretion to think. I agree with you that methodology is something which should be reflected. In terms of CAHI work and Council of Europe and other international instruments, we closely follow. So we have like a kind of observer status, so we contribute. We also contribute quite intensively to OECD, specifically on Council of Europe. Yes, I mean, it has broader scope and it's very welcome. And I think it's very good complementary development. It's not one or another, yes, but of course the mandate of Council of Europe is quite different and it's specifically focused on fundamental rights. So you cannot just compare. And I still strongly convinced, even after all our discussions, that actually it's good that we combine together safety and fundamental rights, you know, so it gives a different dimension on enforcement. And I personally have been working on constitutional law and fundamental rights for many years in academia, and that was one of my biggest assessments. You can have international conventions and wonderful judgments, but if you cannot enforce them, you know, or they just remain written on the books, I mean, what is the relevance to individuals? I mean, of course there is still relevance, but much more limited. So I think that's one of the big, let's say, plus points of EU law, that there is a strong enforceability mechanism attached to the EU acquis, you know, and I think bringing this fundamental rights dimension into the strong acquis existing will provide more opportunities, both for, like, for example, different supervision authorities and equality bodies, for example, to provide more instruments. I mean, of course, it is something yet to be developed and further guidelines or additional instruments that might spin off, but at least I think with this proposal, we managing to bring it into the scope of this debate and not to separate, hardly speaking, this is fundamental rights, something soft, ethics related, something, you know, like we can pronounce the big announcements, but then nothing to follow, you know, into a quite operational scheme, you know. So that's, I think, yes, like I said, and I will repeat, it's not a perfect maybe solution as it is. We are still in the first steps, but I think that was already very important conceptual and analytical step. And that was exactly our conscious step, not to follow exactly GDPR logic, you know, for this specific act. So for this, I just thank you everyone for the great questions, and for Thomas for really great moderation and putting all the questions in clusters. That was an excellent, and thank you to everyone, to Andrea and everyone for this great debate.
Indeed, thanks a lot, everyone. And with that, I will give it back to Andrea, our host in Pisa. I greatly enjoyed the conversation. I appreciate your contributions. This was a lot of fun.
So, yeah, thank you very much. I wanted to thank personally the speakers one by one. It's a pity you cannot be here and enjoy the nice weather and maybe go together for an ice cream. But I'll have to keep this virtual for the moment. Of course, there's an invitation for as soon as it's possible to come visit in and have indeed that ice cream or a drink or whatever you like most. And it was a great pleasure. I think it was a very interesting debate. And thanks for that to all of the speakers. So a big round of applause, even if a virtual one. And also to our chair, who made it a very dynamic discussion and helped the audience that is remotely connected with us, either through Zoom or YouTube, to interact very lively. Let me also thank personally Francesca and Nicoletta and the entire team here, and also one of our PhD students, Elif Bieber, who helped us organize this event and put it together. Without their contribution, it would have never been possible. And please let me take the last moments to remind our audience actually, of the next event that we have up, our summer school, that will take place in July. And this is the 6th or 7th edition. We started back in 2016. So it really tries to discuss the different aspects of the regulation of AI and robotics from different perspectives, taking into account law, engineering, ethics, economics, and also innovation management perspectives. And of course, this year again, unfortunately, it will be a virtual edition, but that's what we can do. And to some extent, this simplifies traveling and does not necessarily reduce exchange, because we found ways to bring people together nonetheless. So there is still a week to go. You can apply through the link that you will see in the next slide. And you still have time until next week to apply if you're interested. So, and if you have any questions, do not hesitate to send us an email. And once more, thank you again for joining us today for this very interesting discussion. And hope to see you soon, eventually in person at some point. Have a nice day.